Lordship. You have already charged, Lordship. May I allow me to take this affidavit?
Want to bring it on?
May I please? In respect of item 20, here on the government, Carbangalong supposed to file affidavit. This is eviction matter, not yet filed. So may I pray, my lord, matter may be taken up another day. We have filed our representation as per your lordship, provided.
You want what?
The petitioner, your lordship has directed to the petitioner to file representation to the authority. That has been filed. But Carbangalong has not filed affidavit. So may I pray for the listing?
You want an adjournment?
Yes, ma'am.
Request of so and so matters can be adjourned to be listed of 6 weeks.
Interim order is there.
Interim order is there. What is the interim order?
Not to take any action until the disposal. We evac.
Yes, what is your?
Not to evict the petitioner.
And? Are you not filing any affidavit?
Okay, I'm praying for 3 weeks time to file my affidavit. Instruction is awaited, Lord. Instruction is awaited.
On 5th of February 2025. Interim order passed earlier shall continue till then.
I am available.
I'm praying for a moving an unlisted matter today. Divya.
May I please, Your Lordship, I beg to mention item 30. Your Lordship, item number, page number 69 and 69A, an important annexure is not enclosed. So kindly allow us to enclose the important document annexure and let it come after vacation.
Want to file an additional affidavit?
Lordship, page number 69 and 69A, these are important documents and we have not enclosed it in the writ petition. Kindly.
How do you bring it? By way of an additional affidavit. That is what you are saying. Counsel appearing on behalf of the petitioner submits that she would like to file an additional affidavit in the matter. This matter immediately after the winter vacations.
I may be allowed to move an urgent unlisted matter.
Thank you, Lordship. In item number 8, in page number 18, there is a mistake, Lordship. I may be allowed to correct that forestry.
We'll see when the matter is taken up.
Motion item 1.
Which department?
GMC Lordship.
Huh?
GMC Lordship.
What has the GMC done now? What is your case?
I'm seeking trade license from GMC for boarding water supply unit, Lordship. I had valid license before, but they had cancelled it saying that I do not have the mandatory NOC. So I approached this court and the court said that I have to move to the state authority. Now, when I went to the state authority said that their portal is not ready. As such, I have to go back to the settled groundwater authority from whom I had already obtained the NOC. Lordship, even after obtaining the NOC from both the parties, I went to GMC saying that you grant me my license. I have not been granted that license now, Lordship.
Now tell me, where is the direction by this court to grant you the license?
Not directly, Lordship. However, there is a submission made
Is
by
there any direction that you should be considered also by the court?
Lordship. I was permitted to go to GMC so that I can obtain the trade license.
You going to the GMC not giving you is a cause of action, which is a fresh cause of action. How can it be a case of contempt? And that too when in the last line of the paragraph number 10, At page 13, the court says that it is a case of a disputed question of facts.
That is only with regard to certain materials which was obtained from me.
But
without-
apart from that, see the earlier portion of paragraph number 10. It's a case of a cause of action, a fresh cause of action. You having approached, they are not giving you it.
However,
File a writ petition.
Lordship, if they say that they do not have any objection. to
No,
the-
how, there's no direction, Where is the willful and deliberate violation to the order? You have been given an opportunity to approach, you have approached, the matter ends there. What remains? The so and so appearing on behalf of the petitioner submits that the petitioner would be well advised to file an application, to initiate appropriate proceedings against the GMC for non-consideration of the applications seeking trade license. So she therefore submits that the petitioner would not like to press the instant contempt petition. The contempt petition accordingly stands closed. The petitioner, however, is at liberty to approach to initiate appropriate proceedings if so advised.
Item 2.
Petitioner being a bed and breakfast establishment has approached this board earlier. Your lordship recalls against action of the GMC in a notice saying sealed my premises provided the proper trade license is not taken and the NOC from the housing society is not provided.
Even the quashing of an order.
Then your lordship has passed an order whereby the action of the GMC was set aside. And it was observed that the NOC, since it's not mentioned in the rules, is not required from the housing society. Now, I have obtained the correct trade license. I have been running since. On 20th of August, the Commissioner of Police passes an order saying that under the Sarai Act 1867,
Which act?
Sarai Act 1867, ma'am.
Fantastic.
That act is.
The central government is trying to eradicate those old acts and now you're bringing in. Yes, tell me.
Already repealed by so many statesmen. Under that act, registration is required. I am not shying away from the registration, my lord. But notice has been served that you file your form, whatever form is required. I submit it. I specify that the NOC from residents, any residents of that society has been given. I'm giving it to you. Then from my landlord also, from the builder also, everything was provided. And the copy of your lordship's order, a certified copy was also provided saying that the NOC from the housing society is not required since even under the Sarai Act, there is no rule specifying for such a requirement. Now, they issued the impugn notice, which is at page 140. 140. They say that from the resident of Ideal Hillview Apartment Welfare Society, you provide the NOC. I give an explanation on the very next page, again repeating the same things. The moment I file this case and this court takes up this matter and directs my learned friends to obtain instructions, on Tuesday, they issue a notice to me calling me for a hearing. This is after 51 plus 26 odd days of processing my application. Now I can take your lordship to the act, to the Sarai Act. Nowhere it is mentioned that there is a requirement of such an NOC. Also, the Sarai Act specifically states that if the state government wants to make any rules under this particular act, then it was required to be published in official gazette. Now, there is no certain rules of the Assam government, madam. So, my challenge is against that particular requirement.
What is the Sarai?
And it's defined at page 128, madam. Sarai means any building used for the shelter and accommodation of travelers and includes in any case in which only part of a building is used as a sarai, the part of so used of such building. It also includes the pura so far as the provisions of this act are applicable. And the commissioner also defines it in his order at page 124.
So means any building used for shelter and accommodation of travelers.
I will come under that particular definition, my lord. And also the order of the commissioner states that any such premises.
But has this act been at all followed anywhere?
My lord, so far as my instructions, my lord, all the hotels have applied for it and they have been provided. And they are only not issuing the NOC to those particular bed and breakfast or homestay facilities which are situated in any housing society. I have approached this court and I have not seen any other establishment approaching till then.
Well, on last occasion, Lordship has directed us to obtain the instruction as regard the status of his representation, number one. And number two, my lord, the number of Sarais already registered in Guwahati. My lord, my instruction is there. Kindly see.
And what is the power of the commissioner of
The
police?
commissioner kindly at page 129, the magistrate of the district. There is a
Huh?
definition. Magistrate of the district at page 129. Sarai Act.
Within 6 months after this act shall come into operation, the magistrate of the district
Magistrate of the district
in which
means
a sarai to which this act shall apply may be situated shall, and from time to time thereafter such magistrate may give to the keeper of each such sarai notice in writing by leaving such notice for the keeper at the area, and shall require such notice. Magistrate shall keep a register in which shall be entered by the so and so, so and so. After the month after so and so, magistrate may refuse to register keeper not producing certificate of character. Now, what are you asking for?
but, if Lordship kindly comes to the page 129, Lord, the definition, magistrate of the district. The magistrate of the district means the chief officer charged with the executive administration of a district in criminal matters, whatever may be his designation. So
So there you say that the commissioner of police has the
Yes.
power.
he is the authority of the under this magistrate of the district. Under this act, he is the authority.
Then
Well, my instruction, kindly see my instruction block. Serial number 2. The number of sarais already registered in this office till date is 457. Other 309 other applications are under process. And well, the number 1, kindly see, as regard the consideration of the representation, they have fixed the date for his personal hearing, block, that is today, block. Well, my respectful submission would be, block, the representation at page 141 is under consideration. I pray, block, that it may be taken up to the vacation, block. In the meantime, block, they will consider the representation and pass a order. And kindly see, block, the instruction at page 3, block. The second page, kindly see the second para. That is why, block, they have asked for that. In page number 2, block.
so the hotels are.
Hotels and all this, the bed and breakfast, that is what they want to use. That those are to be registered of the Sarai Act. There is no dispute, and the authority who has issued the notice.
So now you are not giving him the registration.
because of some the inspection report. The inspection report indicates that there are some complaints, therefore they have sought for the. Yes, in the inspection report, it is in the instruction, we have annexed.
My learned friend himself has read that it's a criminal, and if there is any criminal antecedent, my lord, your complaints will not do. Where's the FIR? Where's the criminal antecedent?
Let the representation be disposed of, they are considering the representation. Lordship may,
After 51 days from submitting my form,
but the inspection report.
and after 26 days from submitting my representation. They have
No,
all-
here you will see number 6.
Yes.
Magistrate may refuse to register keeper not producing certificate of character.
My,
The
my,
magistrate may, if he thinks fit, refuse to register as a keeper of a sarai, a person who has not produced the certificate of character.
I have that, my lord. I have annexed it.
You can. 9 only comes after registration.
But the
Kindly see the words.
inspection,
Power to shut down, shut up, secure, clear, and clean. Deserted sarais. Means it has been registered.
no, it is not yet registered.
If it is not registered, how do you exercise the power under 9?
Instruction says that without registration, that particular sarai, the petitioner has been running. Kindly see my instruction, the page 2, my lord. The second page. In
Yeah.
this particular case, Hillview Bed and Breakfast owned by Srimati so-and-so was running illegally without registration under the Sarai Act 1867, violating section 5 of the Act. Section 5 states that after so-and-so the provision has been quoted. Then, my lord, there was complaint received by authority about nuisance being created because of unauthorized running of the said guest house, which attracts provisions of section 9 of the Sarai Act. On 30/8/2024, the Ideal Hillview Resident Welfare Society lodged a written complaint by memo number so-and-so against BNB or BNB guest house concept in Ideal Hillview apartment. The Ideal Hillview Resident Welfare Society informed that earlier an incident took place in their apartment. Whatever it is, where some outsiders entered into the apartment by representing them as the guest of the guest house in block number C, flat number 11A, and block number A, flat number 8A. And their names also found missing in the register. The said complaint has been entered into Nunmati PS record by GD entry number so-and-so dated 30/8/2023, and an inquiry has been initiated. During PS inquiry, the inquiry officer had recorded statements of several residences of the residential society wherein the society members strongly opposed against
No, no,
BNB.
Mr. Nath, we are concerned with one thing. When he has applied for, why you have not given him?
But in the inspection report for registration, there has to be an
You
exception.
will go for an inspection under what provision?
But before registration,
Under what provision?
they have.
Because you have not formed the rules. Have you framed the rules? So under such circumstances, where will you go for inspection? Tell me.
But anybody.
No, you cannot.
Anybody
If the
can apply
law
the
does
right.
not permit, law only permits only one thing. That is why I'm saying, why you are invoking an 1867 Act? If you have not framed the rules, the law does not say that there will be an inspection. The law says that he has to only give a certificate of good character. That's all. Finally, see, 9 will only come in if there is a sarai where there is all these things which are there. That there is some nuisance is being created in a sarai. He is not a sarai till now unless it is registered.
But he is not registered, but he has been running without the registration.
For that, you take any action. That is another thing. I'm not on that. But how can you stop him from registration?
No, you are not stopping.
You are nobody to make any inspection unless you have the rules. No. Not, Mr. Not nothing. You have to, have you given the good certificate? Good character? Matter over. Give the certificate. Give him the registration. Thereafter, you take whatever action you may. You don't have, today you can't do this. Why are you bringing into all these things? And means, kindly see the act.
But that we have seen. Mala, this is the
And
standard.
at that point
This
of
is the standard
time,
procedure.
when the British was there,
But this is the standard.
British
procedure.
came in 1926, 1826, and thereupon has come up with this thing. That there is some regulation required. Now you are putting it in embargo on everything.
But final decision has not been taken. This is the procedure we are following. Mala, the
What
inspection report-
other procedure is there? What are the other requirements for getting a registration? Tell me.
the inspection report.
He has to come within the meaning of a sarai to apply. He says that he comes within the meaning, as such he is applying.
That application.
The only requirement is a certificate of good character.
Whether that certificate is in fact correct or not, only that has to be verified.
You have only to see the certificate of his good character, the keeper's good character. You are not going to inspect anything else. Thereupon, after registration, if anything happens, then you exercise 9.
This is the standard procedure. we
This
have
is
to-
high-handedness.
Kindly.
This is high-handedness. Nothing doing.
Well, his
We stay
representation
all
is
the
pending.
proceedings, give him, allow him to run. You are
But,
running,
Let us file the.
you run,
application.
properly run.
Kindly allow me 1 day. time.
Absolutely nothing.
But
This,
is-
Mr. Nath, I don't understand why the state has this problem with it.
no, state
What
has
is,
no
what is
problem.
wrong with this? Why are you bringing an 1867 Act?
No, no.
Yes, you ask him to make it, get him registered. He has Tell me what else? Where do you go for inspection and go and ask from other complaints? After it is registered, you have the power.
But my
You don't have the
instruction is-
power otherwise.
My instruction is that already we have registered 457 and this is a continuous process Malad, going on and this is this.
When have you registered from 457?
The figure, Malad,
Has it been registered from 1867?
No.
Tell me, show me the first of the registration. Is it in 1867? Then, because it had to be done within 6 months from that.
the details is not.
Yeah, you are having having trade license aspect. You have many other, various other facilities, various provisions out there, how it is to be done. The GMC duly regulates all aspects of the matter. Now you are coming up with all these things. You want to exercise power, exercise power, but you run your
No, We are,
their state,
we are regulating the thing, Lord. Kindly-
provision,
kindly
and
see,
allow, we
this is
allow
the
you,
standard procedure.
we allow you to
Police.
run. If they don't register it, then let it go to here.
But, I will
Heard
be allowed
Mr.
to file
Peeber.
the-
No, nothing
One
doing.
minute. Let us
Nothing
finish
doing. No. Heard Mr. Peeber, was the learned counsel appearing on behalf of the petitioner. Mr. D. Nath appears on behalf of the. Heard, issue notice, making it returnable by 5th of February 2025. Home and political, you appear?
Aye.
Mr. D. Nath accepts notice on behalf of respondent number 1, 2, 3, 4,
All.
5, 6, 7. Post extra copies of the writ petition be furnished to him during the course of the day. The case of the petitioner herein is that the petitioner had that the petitioner number the petitioner number 1 is a proprietorship firm of the petitioner number 2. Full stop. The petitioner number 1 is in the business of running a bed and breakfast establishment in a flat owned by him, being flat number A-8A, and another flat rented by him, her, no? Rented by her, which is flat number C-1B in the ideal Hillview apartment. Full stop. It is seen that on an earlier occasion, the petitioner was stopped by the GMC authorities on account of not having the proper trade license. And it is under such circumstances, the petitioner had approached this court by filing a writ petition, which was registered and numbered as WPC number 650/2024. This court, by an order dated by the judgment and order dated
16/7/2024.
16/7/2024, disposed of the said writ petition with an observation that in the circumstance the petitioner obtains the trade license for homestay in respect to both the flats in question, the petitioner would be able to run the bread and breakfast facility subject to fulfillment of other formalities which is required under law. So it was further observed that the respondent authorities, more particularly the GMC, cannot insist upon the no objection certificate from the residents of the ideal Hillview apartment for permitting the petitioner to run its bed and breakfast. Full stop. Pursuant to the said judgment passed by this court, the petitioner obtained the
My lord, at page 122.
obtained the trade license from the GMC authorities and was running its bed and breakfast facility. On 28, 2024, the Commissioner of Police issued an order thereby issued an order containing the following directions, which are reproduced herein below, page 125 of 1, 2, 3, and 4. It was further mentioned in the said order that for the purpose of registration of the Sarais, the establishment of the Deputy Commissioner of Police Intelligence is authorized on behalf of the Commissioner of Police, Guwahati, to process all such applications received from the keepers of the Sarais. Pursuant thereto, a notice was issued by the Deputy Commissioner of Police Intelligence on 28/8/2024 to the petitioner, informing the petitioner that the petitioner, being an owner or keeper of a sarai within the police commissionerate Guwahati, must have his sarai registered, and that the register is to be kept in the office of the Commissioner of Police Guwahati. So it was further mentioned that if the petitioner did not register, he would be liable to penalty as prescribed in the Act. It was also mentioned that upon applying, the petitioner would be petitioner's establishment would be registered as a sarai. The petitioner thereupon immediately, that is on 31/8/2024, submitted an application for registration as a sarai. For a period of 3 months, nothing was done. On the other hand, on 19/11/2024, the petitioner was issued a notice by the Deputy Commissioner of Police Intelligence to submit the NOC from the resident of the Ideal View Ideal Hillview Apartment Welfare Society for further processing of the application. The petitioner thereupon submitted a representation on 22/11/2024, stating inter alia that as per the Sarai Act of 1867, there was no requirement of submitting of such submission of such no objection certificate. The petitioner further requested that his application, the application for Hillview, for application for bed and breakfast facility be approved under the Sarai Act 1867. Full stop. The respondent authorities, however, did not consider the said aspect, and it is under such circumstances the petitioner has approached this court by filing the present petition. Full stop. This, it is seen that on 17/12/2024, this court, when the instant writ petition was listed, Mr. Dina, the learned counsel appearing on behalf of the respondents, sought time to obtain instruction as to why the petitioner's application have not been decided till date. Pursuant thereto, the matter was listed before this court today. Mr. Dina has placed before this court a set of instructions dated 19/12/2024. In the said instructions, surprisingly, there is nothing mentioned as to why the petitioner's application have not yet been considered. Rather, it has been mentioned that there was a complaint received by the authority about the nuisance being created because of unauthorized running of the said guest house, which attracts the provisions of Section 9 of the Sarai Act 1867. It was mentioned that on 30/8/2024, the Hills Ideal Hillview Residents Welfare Society had lodged a written complaint. It was also mentioned that the Hillview bed and breakfast owned by the Srimati Sima Borua was inspected by the inspecting officer from the Nunmati police station, during which the residents of the Hillview apartment where the guest house is located objected and opposing the running of the Hillview and breakfast in their locality. It was mentioned that in view of Section 9 of the Act of 1867, as complaints were received, the no objection certificate of the neighbors of the residential society has been sought, for while accepting the application for registration of any Sarai. This court have duly, the said instruction is kept on record and marked with the letter X. This court have duly perused the provisions of the Sarai Act of 1867. From a perusal of the said section, it reveals that from a perusal of the said section, and more particularly, Section 3, This court have duly perused the provisions of the Sarai Act of 1867. From a perusal of section 3, it is seen that a duty has been imposed upon the magistrate of the district to issue notice to the keeper of the Sarai, requiring the keeper to register the Sarai It is further seen that section 5 puts an embargo not to register a Sarai, not to receive any lodgers, etc., unless the Sarai is registered. Section 6 stipulates that the magistrate may refuse to register keeper not producing a certificate of character. There is nothing. There is no other. This court have further perused the other provisions of the Sarai Act of 1867. Except furnishing a certificate of good character, there is no other document which is required for the purpose of registration of a Sarai. This court, taking into account the above, is of the prima facie view that the withholding of the registration by the respondent authority, more particularly, who is the commissioner is respondent number? And the deputy commissioner?
The commissioner is respondent number 4, my lord. And the deputy
Respondent number 4 and respondent number 5. On the ground of the NOC being not obtained from the society, welfare society, ideal view, what is
Ideal welfare society.
welfare society? Prima facie appears to be in violation to the provisions of Article 19, 1G and 21 of the Constitution, violence of Article 14, 19, 1G and 21 of the Constitution. Under such circumstances, this court directs the respondent authorities to consider the application in the interim, to consider the application of the petitioner for registration of the Sarai only on the basis of the certificate of good character, which is the mandate. This court further takes notice of the submission made by Mr. D. Nath to the learned senior government advocate to the effect that certain inspections were carried out, has to be carried out. This court finds nothing in the Sarai Act of 1867 which empowers a prior inspection before registration. This court have also put a pointed query upon the senior government advocate as to whether the rules under the Sarai Act of 1867 have been formulated, which may otherwise have permitted such inspection. Candidly, the learned counsel submits, senior government advocate submits that no such rules have been been framed. In that view of the matter, this court, in the interim, in that view of the matter, in the interim, this court directs the respondent authorities, more particularly the respondent number 4 and 5, to consider the application for registration within 10 days from the date from today, on the basis of the certificate of good character of the petitioner. Full stop. And thereupon pass appropriate and thereupon register to take a decision on the within 10 days to take a decision only on the basis of the certificate of without insisting on the NOC from source. You cannot continue without the Sarai. You have applied.
My lord, at the very beginning, it will be flat A88. The other flat I have given.
Flat, only one flat.
Only one flat now, my lord. A88.
Eta flat, huh?
Item 3.
Oh, on the next date, the senior government advocate shall also produce the list of Sarais registered under the Sarai Act of 1867 and from when such Sarais have been registered.
Wait, please, my lord.
Yes, what
My
is
lord,
this?
we have filed an additional affidavit, my lord.
Ah,
If the lordship would kindly have the additional affidavit for a moment. my lord.
wait, what are you challenging?
Basically, my lord, we are challenging the NIT. Now, if a lordship would kindly come to page number 88, my lord. This is an office memorandum issued by the
88.
Finance Department, page 88. In fact, my lord, it goes to the root of the matter. In supersession of all previous notification relating to e-procurement, etc., etc., etc. Then the last three line, the Finance Department hereby directs that all procuring entities specified in subsection 2 of section 3 of the Assam Public Procurement Act 2017 to adhere to the following. A. Government e-marketplace GEM is mandatory for all procuring entities for procurement of all goods and services that are available in GM. So all these items are available, my lord. 2. In the event that these specific goods and services are not available in the GM, the procuring entity shall mandatorily procure the same on Assam tender. So, my lord, here is a case.
Or above 20 lakhs.
It's 46 crore.
This is for value
Yes,
above.
whichever is 20 lakhs above. Now, my lord, page number 91 onwards, these are the documents to show, my lord, the items which has been, my lord, in respect of which bid has been issued, these are all included in available in the GEM, my lord. For example, this half shirt, then, my lord, page number
Let us see the
94.
tender which you are challenging. Let us see that.
Yes, yes.
Okay. Yes,
Lord,
there.
the tender is at page number,
Oh, yeah, 30.
yes, 30, my lord. Basically, my lord, page 33,
Invites for textile and garment manufacturers having their own house for spinning, so and
Yes.
so. And so. What is the goods sought for?
my lord, the eligibility criteria at page 33, my lord. Supply of school uniform at page 33, scope of work towards the bottom. Supply of school uniform to 6,59,141 students. That is so-and-so pair. All goods need to be supplied effort at school. Estimated value 46.13 crore. And
Now-
when the eligibility criteria is at page
Now,
30.
what is your case? You want it in the GM,
Yes.
not in the Assam portal. Why?
So, my lord, my challenge is twofold. Basically, our challenge is, my lord, under the national scenario, my lord,
these procurements are supposed to be made decentralized. Basically, school management committee should make the procurements. This type of big procurement is not permissible. There is already a judgment of our High Court. My lord, they might say that this procurement we are making out of our own fund. Therefore, there's a judgment of our High Court, my lord, where it says in respect of that it comes. But in any case, now in view of the their OM issued by the Finance Department, they have no option but to go through GM. They have
Now,
selected.
how are you affected?
My lord,
How are you affected if you go
What?
through GM or not?
no, once the lord.
I would have understood. They have gone for this local tender types,
No, my lord.
short tender notice,
No, my lord.
which BTC does.
No, my lord, my lord, here, lordship is in a 226 proceeding, my lord. In a given case, lordship also considers that if in the GEM, it would have been there, many other eligible players would have been before
But
the.
who are you?
My lord, I am a contractor.
So
I'm a
how are you
supplier.
concerned? You are a doctor, very well. You can see Assam portal here. You can very well participate. Why you are challenging here? No locus.
No, no, my lord. My lord, our,
Here, if it is okay, if it is not otherwise, why you are going for GM?
no, no, my lord, that's the procedure. I did not
Understood.
show any
How are
prejudice.
you affected?
No, it's not normal. That's what, when there is violation of
Then
fundamental
better
right,
go
I
for the
did not
public
give
interest
prejudice.
litigation. Mr. Chaudhary, it's a case of public interest litigation.
No, no, it's not.
Then for others are different.
With all humility at my command, I'll submit, my lord. In case where there is a violation of fundamental right, I need not plead prejudice, my lord. That's the settled position of law.
Where is your fundamental right to
My
lost?
fundamental right is to participate,
Participate.
but not in this forum, as is in this age.
Why?
At least see, my lord.
Why not here? I don't understand why you can't participate here. You are duly registered.
There are twofold challenge in this case. One is, my lord, the terms are arbitrary because idea the level playing field is sought to be not there because under the original scheme of things, my lord, the procurement should have been decentralized. It is the school management committee who should make the purchases.
Where is that?
Yes, my lord, there is already a judgment. That we have a next, my lord.
When is the judgment?
Yes, yes. At page 64. Page 64, my lord. And the operative portion is at page number 80. Para 51. In view of the discussion made above, this court is of the considered opinion that impugn eligibility criteria contained in EOI in the facts and circumstances of the case is arbitrary and hence unsustainable in law. Having held as above, this court would have ordinarily gone on to strike down the EOI. However, having regard to the mandate of clause 7.4, read with 7.7 of the FMP, and keeping in mind the interest of the school student, balancing the equities, these repetitions are being disposed of with the following observations and directions. The respondent number 3 may prepare a panel of vendors for supply of school uniforms as per the impugned EOI, but the operation of panel shall be kept confined only to those individual supply orders, net value of which exceeds 25 lakhs. Panels so prepared will remain valid only for a period of 1 year from the date of the notification. For supply orders valued at less than 25 lakhs, the principles and procedure laid down in clause so and so shall be followed. In the matter of procurement of school uniform, respondent numbers 1, 2, and 3 shall not in any manner encroach upon the autonomy vested upon the respective SMC under the Act of 2009 and the rules framed therein. So, my lord, by way of the additional affidavit, we were trying to project that issuing this NIT in this Assam tender was also not correct.
Now, if it is procured from GM, you are okay.
So, my lord, once in the GM, there will be certain restrictions.
Huh?
Now, my lord, there's one more thing. Lordship will kindly have this for a moment.
Because GM will go outside then.
It's not a question of inside or outside, my lord.
No,
When their action, they themselves proclaim that if the value of the, procurement is above 20 lakhs, then it has to be mandatorily by GM. That is the first requirement.
no, if it is available in the GM.
Yes, it is available. That's why I have given.
No, if it is available in the GM,
Yes.
so how does it help
No,
you?
my lord, supposing a particular item in respect of which procurement is to be made is not available in the GM portal, then even if it is above 20 lakhs, it is not mandatory. But here is a case, all these items which are sought to be procured are available. We have brought on record by filing that affidavit, additional affidavit today, page 91 onwards. These are the materials which are school uniform which are sought to be procured. My lord, if you also could kindly point me
No,
to
Mr.
place this
Chaudhary.
for a moment.
Mr. Chaudhary,
Yes,
the two arguments which you are placing
yes.
are different, completely on a
Now,
different
for
line.
example, my lord,
Yeah.
let's have a look at this Roman 4. I can go ahead. My lord, this is the rule, my lord. I will show copy of this. Yeah, that will be good. Roman 4, my lord.
Yeah.
No, I don't have it. No? It's not that.
Understood? No,
Ah.
the finance department is
Yes.
overall everything.
Yes.
That I could understand sitting outside. Means, but the question is, how do you means both the arguments which you are making are completely on different side.
The case which we made out in the writ petition is
It's on the basis of Justice Shyam's judgment.
Sham judgment that the procurement has to be decentralized.
Hmm.
My lord, end of the day, it is the government of India who decides.
Hmm.
Because it's an education. Education is a subject under entry 25.
Hmm.
So, my lord, when there is a central prescription prevailing, then even if the state makes any prescription, it cannot override the central prescription. That's the fundamental thing. So therefore, my lord, normally all throughout it was, I think, before this 1920, when that judgment was rendered, which you have referred. Prior to that, my lord, practice was the procurements were made in a decentralized manner. Now, then they wanted to do that. Then this court intervened. That is our basic ground of challenge. Additionally, my lord, why Assam tenders? Why not GEM? When the rule itself prescribes. We did not pose any question in my humble submission, my lord. The moment it is not in GEM, it's bad. And one more amendment they have brought in, my lord. If your lordship should kindly take the additional affidavit, how they are trying to restrict the competition. If your lordship should
But you are not in the GM portal. You are not in the GM portal.
Yeah, well, there is no bar on us. Only thing is, well, supposing a particular item which is sought to be procured is not included in the portal, then even if that it exceeds 20 lakh, then Assam government can adopt their own thing. But once the item which is sought to be procured is available, they're bound to do it. That's what the OM says.
No, but are your products in the GM portal?
Yes,
Show us the.
yes. That was given in the annexure, Miller. Page 91 onwards. Page 91, Miller. This is men's casual.
No, I am asking, are your products in the GM portal?
My product, Miller,
No, because no, kindly see your statement in paragraph number 4. of the writ petition. You say that you have your own in-house facility for spinning, weaving, processing, and stitching located in India under one PAN card.
Huh.
So therefore, I'm asking you,
No, but
come with the, because one has to test this argument. One argument is of Justice Sham's judgment.
Yes.
That is one aspect. The other, as to if you are not in the GM portal,
no, look, a bidder cannot be in the GM portal, my lord. GM portal one can access. Question is the product which is sought to be
no,
procured.
no, is your product under in the GM portal? That is what
Not
I'm
my
saying.
product, my lord, but the product which is sought to be procured, that is available in the GM portal.
How does it help you?
No, it's not a question of helping me. It's a question of when it is available, then how the procurement will be made as per the OM. It is in that context it is relevant. my lord.
No,
Your lordship,
But then also one has to see
I
a
need
more.
not be in the GM portal. I can always access
No,
that.
no, your basic case out here in
Yes.
your petition is that look here, I am a small industry, small
I'm
scale.
a small unit.
I'm a small scale industry under the Udyan. I have my own spinning mills and all. Now, what they have done, they have gone for such a thing that the eligibility goes beyond my eligibility.
beyond my
And then as such, they should decentralize and give it to us. This is your case. Now, bringing in the GM portal aspect, by which I would have understood there are many people who has their goods in the GM portal. You have to put it on sale, and there is a one who purchases, one who sells it. The seller has to be in the GM portal. So to take that submission, we may say it, okay, in the alternative also, they could not have gone for that. They should have not done through the Assam portal, but they should have gone for GM portal. That is another aspect of the matter. But that is not a serious aspect of the matter. The main aspect out here, because this aspect is for the two judges to decide, not a single judge. But your main aspect is on the Justice Sham's judgment,
Yes.
on the decentralized, because we are small scale, we
Yes.
cannot meet.
And also
so-
what we are doing it, and where do we go? Now, my lord, at page 91 onwards, I have brought out that. And my lord, there's
But
one
your
more
name
thing.
is not there in the GM portal. You are not a seller in the GM portal. That is the problem.
We are not.
So therefore, bringing that, now on the other hand, you have a chance here.
But I'm saying, I need not be a seller in the GM portal, my lord, to subject to correction, my lord. I'm not very expert in all these things, my lord. What I understand is, as per the government's OM, even if the value of procurement exceeds 20 lakh, and if the product which is sought to be procured is not available in the GM portal, then GM need not be availed for issuing the bid.
So they then can go for e-tender in the
What they
Assam
going?
portal. Understood. Now,
To
if
that
I,
extent only, my lord, we are relying on the OM.
if I have to accept this additional affidavit,
Yes.
means it amounts to negation of your right to participate. Because you are not in the GM portal.
Well, I think I have not been able to clear.
I
my
understand. Your thing is that look here.
I
First
need
of all,
not
they
be
have
the-
they have made it in a large scale manner by which we are
They are
totally
seeking to
excluded.
oust us.
We are ousted. But secondly, they could not have gone it in this manner because of the GM portal. That is your argument. But if I have to accept this, means that you want yourself to be ousted because you are not there in the GM portal. I would have understood if you were in the seller in the GM portal, okay. If they would have gone, I would have said okay. That is the problem which I am saying. So we are therefore to be first, because otherwise you will say if you are not a seller, means you don't.
Or lordship, just to articulate it, my lord, or lordship may take it this way. The fact that the tender is not in GM, it goes to the root of the matter. This tender cannot withstand
But
legal.
who are you?
I'm a tenderer.
You can't tender. You cannot. If you are in the GM, it is done also.
I need not be in GM, my lord. I think I'm not been able to make my things position clear. I need not be in the GM portal. What should be in the GM portal is the product which is sought to be procured.
How are you affected?
My lord, that's no, my lord.
Just for let us assume.
There my argument would be, my lord,
Yes.
if there is a violation of a statutory prescription, then it's a violation. That means equal opportunity has been denied. Therefore, it will be violative of fundamental right. Supreme Court says, my lord, when there is a violation of fundamental right, prejudice need not be proved.
Where is your violation of fundamental
But
right to
that's what-
you?
But because equal opportunity has been denied to
Who-
bidder.
To you, how is it possible?
Kindly see, it's a public law remedy. Lordship will also take note of people who may not be before your lordships. Because we
Therefore, I said that it is a matter for the division bench.
not saying that. Lord. Otherwise, also, whenever your lordship decides to take up a matter on the public law remedy side, there is always an element of public interest. And that public interest is decisive. Now here, if there is their own prescription, their own statute says this tender should have been come to GEM. It has not come. So I think that should suffice.
Not at your behest with, anyways, we'll take care of it in the order. And okay, now let's see your first point.
Yes,
Second point, I'm not satisfied.
yes.
Why did the court interfere with, because in that case, as I could see the judgment of Justice Shyam,
Yes.
so he said, because at that point of time, out
They
here,
also,
this
they are
six.
also in a similar fashion. These all small time players were sought to be ousted.
Then why did the court interfere?
Court interfered because the purchase which was sought to be made was not through the SMC. It was centralized purchase, as the present effort is.
Is it the mandate of law to do it?
Yes,
That is, where is it?
yes. Here it is quoted in the judgment, my lord.
Yes, which paragraph? Para 19, you are referring to
Yes,
page
my lord.
72?
Yes. Yes, please come to page 74, my lord.
All procurement will now be.
Yes,
through
para
frequent-
27. Chapter 7 of the FMP deals with procurement. Clause 7.4 lays down the guideline for procurement activities under the new scheme. Clause 7.4 is reproduced herein below for ready reference. All procurement will now be through single implementing society due to subsuming of the three schemes, namely SSA, RMSA, and teacher education, and henceforth the procurement of goods and services and civil works would get regulated through single implementing agency. Procurement of goods, services, etc. has though been mentioned at various levels, but however, for economy and bulk procurement, state can decide the level. Procurement of uniform being provided at the elementary level may also be done at the state district-wise level, but involvement of participant of the community should be encouraged. Procurement of textbook, elementary can be made on a single tender basis. Clause 7.7 of the chapter 7 lays down guiding principle that would have to be followed, and the type of procurement mentioned provided in GFR. Clause 7.7 is extracted herein above. And similar, up to 25,000 no tender. Then from 25,000 to 2.5 lakh, 3-member committee, that's the school committee. Then Millard 2.5 to 25 lakhs limited tender. Open tender above 25 lakhs. So idea is, Millard, not only the procurement would be decentralized, there should be an public participation. In other words, my lord.
How
this-
does the single judge take note of this? 7.7,
Yes,
7.3, na?
yes,
7.4 Roman 3.
yes.
How does the single judge take note?
Para 29, a plain reading of clause 7.4 and 7.7 would go to show that while the state has been left with the liberty to make procurement through simply single implementing agency, yet under subclause 3 of clause 7.4, involvement and participation of the community has been encouraged. In other words, clause 7.43 provides that the level of procurement may be decided by implementing agency, but same should aim at encouraging community participation in procurement process. The aforesaid provision, in my opinion, lays down policy statement of the government, therefore cannot be ignored by the implementing agency while choosing on a procurement process. Clause 7.7 prescribes different procurement process as per prescription of GFR 2017.
Can we come to paragraph 33?
Yes, sir.
The last line,
Coming to the question
I'm
of
in-
community
I'm
participation,
inclined to hold.
I am inclined to hold that idea behind including state within class 3 is to promote wider participation of members of the civil society in the matter of procurement of uniforms. My lord, end of the day, my lord, if this such a procedure is adopted, the common people get pound of flesh, my lord. Otherwise, this whole will go to one or two big businessmen.
And the cell respondent number 3 may prepare a panel of vendors for supply of Iman as per the impugned so and so. For the operation of the panel of so and so, the panel shall be for supply of the value that less for in the matter of Shreya, respondent number 1 to interest shall not in any manner encroach upon the autonomy vested upon the Iman under the Act of Iman and what did the court say about interfering with this 37 lakhs? Because here the uniform was 37 lakhs.
Here, my lord, if your lordship will kindly come to page the para 51,
51. What does it say?
A.
Yeah.
Respondent may prepare a panel of vendors for supply of uniform, school uniform as per impugned UOI, but the operation of the panel shall be kept confined only to those individual supply orders, the net value of which exceeds 25 lakhs. So below 25 lakhs, my lord, they are to follow the procedure prescribed in the FMP. But once at the micro level purchases are made, there's hardly anything will be left. So idea is to, my lord, stick to it. And they were doing it, my lord, pursuant to the judgment.
Okay. Yes, Mr. Rukitani.
There are two facets of the case, lordship. One is regarding whether it should be done,
My lord, with your lordship's kind permission, can
whether the tender should be done centrally or decentralized manner. This is the second argument, and the first argument regarding the portal. What are,
I'm not
I
satisfied.
am the lordship, these are two different platforms. And why we have done it? Because for your school uniform, dokna and certain traditional dresses, which are not available in the GEM. That is why we have opted, and there is a finance department note also for us. If it is not available, as the mandatory GM procurement does not apply in this case, the department may proceed on the alternative procurement method. These are two different methods.
No, that is okay.
Nobody is prejudiced by that.
Anyways, here,
Yes.
if he was a seller in the GM, I would have understood.
Yes.
He's not.
Now, regarding the other part, whether it should be done decentralized manner or centralized
That is
manner
the-
in terms of the FMP, the finance manual of the central government. Another case came up before this honorable court in 2023. I did not have the these printed copies. Hemanta Kormakar versus State of Assam, including Union of India, WPC 272. One is 523 of the 2023, and the other one is 7967 of 2022. These two cases come up last year and it was finally disposed of this year. There are two cases.
When is the last date of submission of tender?
Yesterday it was over.
Over?
It was over. The interim order which was passed on the first day, that is 3 days ago, not
Interim
to
order
open
was
the
passed?
tender.
What is the interim order?
1812,
Will not be opened.
yes. Day
And
before.
when is the opening date?
Fact, yesterday was last date, so today also we can open it if this order is vacated.
Then-
Because there is urgency regarding these are uniform,
No,
we
no,
have
yes,
to
yes.
supply
No,
in
that I
March. The session will start in March. So now the case is well settled.
What does the 2023?
Yes,
judgment
that judgment, there are two cases regarding the same SSS procurement of furnitures. There also, we have done it centrally. Two scopes are there, two tenders were challenged. One with the state fund, that is SOPD fund. The other one is the central government fund. The learned single judge of this honorable court in the central government funded made it binding on us to follow the central government manual. That means we have to do as per that norms, not decentralized through the school management committees. So far as the state government fund is concerned, the Honorable Court allowed that state government can adopt any method. It has left to us.
But
This
is-
particular case is totally state government. They have structured the petition in the manner as it is central government fund. No, I have the written instructions. Lordship will kindly see it. This is a purely state government fund, SOPD funding. I have the sanction letter. I have the written instructions, and we have also quoted the judgment. So they have given the 2013-19 judgment. They have deliberately kept out the purview from the other judgment.
Oh, this is the financial sanction by the education department.
Yes, Lord.
So government of India.
Has nothing to do here.
How you do it, that is your look.
Absolutely. And the Honorable Court directive, paragraph 22, that is quoted in the instruction.
Yes.
The second page. 22.1 of that Hemanto Sarkar's case, with the fund to be utilized in the tender process initiated by NIT dated 13/1/2023.
And where is that Dokna thing? You are getting from something else, no? That the school uniform will have different, which is not otherwise available in the GM.
That is our verbal instruction, but I have in the instructions, Lordship will kindly see the finance department note also. The last page down below. This is in response of another similar situation where the products were not available. Then finance department says, as the mandatory GM procurement requirement does not apply in this case, the department may proceed with alternate procurement method, such as the Assam Tender Procurement Portal as per existing guidelines,
Okay.
and does not
Okay,
need to
okay,
seek
okay.
finance department.
Now what to do? Dismiss. Intend to vacate, but dismiss or what? Or allow them to file an affidavit, you file a reply, but I'm vacating.
Lordship,
Don't have a case.
my submission to be, Lordship, the GM portal did not have any restriction that such person can participate in the process, having the spinning mill and weaving unit and everything. That is why, Lordship,
You are not a seller in the GM portal.
nothing not required, not required. GM is a portal where any person can participate in tender process. There is no question of restriction, nothing. I have this, Lordship, the GM introduction book. GM is a portal like e-tender, it is a process. Anyone can participate in tender process, but in case of GM, they cannot insert a clause that such and such person can participate. Here, Lordship, to
So here the finance department circular. Finance department has given an approval.
finance department circular, I have noted, Lordship, finance department circular said that when it is not available in GM, then they can.
That is what the finance department has stated. They have taken the clearance from the finance before going for the tender.
That was in respect of another one identical situation where the products are not available.
So here you isn't it
Yes,
the
I have
last
given
page?
it. Because identical situation when the product is not available in GM or portal, Lordship, then we can always obtain.
Yeah,
So
it
this
is
is
the
the principle
department
followed by
area.
finance.
As per the mandatory GM procurement requirement does not apply in this case, the department of, isn't this the requirement?
This is, I am giving it from another case, but the same principle is followed here applicable because here the
You
uniform
must be
consists,
having the financial aspect,
Lordship,
the finance, have you taken the clearance from the finance?
what finance has finally said here that such as Assam portal as per example and does not need seek finance for approval for such cases in future. Last line, Lordship, we can
Is
read it.
this portion not
It is
in
applicable
connection
the
with
case-
this case?
in this, because the line says, and this does not need seek finance department's approval for such cases in future.
Where?
In the same noting down below,
As the mandatory GM procurement,
requirement does not apply in this
here, the
case.
Department may proceed with
Alternate
alternative
procurement
methods
methods
such
such as
as
Assam tender
and does
portal.
not need the finance department's approval for such case in future.
My submission will be, Lordship, in this particular
Okay,
case,
now what do you want? Intend to vacate? Pendency or no pendency? Pendency.
Let us file an affidavit, Lordship. They have to, because
Mr. K. Chaudhary, the learned senior counsel, appearing on behalf of the senior counsel, assisted by Mr. S.K. Gustami, appearing on behalf of the petitioner. I've also heard Mr. D. Soikia, the learned advocate general, assisted by Mr. S. Bora, appearing on behalf of the state respondents. You are for? Higher?
Union of India.
Okay, Mr. So appears on behalf of the Union of India.
Because there is nothing on record.
Of issue notice making it returnable on 10th of February 2025. Steps be taken upon the respondents. Now, the Google accepts notice on behalf of the respondent number one, Mr. Elbora appears on behalf of, accepts notice on behalf of the respondent number 2 and 3. Extra copies of the petition be served upon them during the course of the day. The case of the petitioners herein who claim to be small time, who claim to be small scale industry, who claim to be entrepreneurs having registration as small scale industry under the UDAN, have approached this court challenging the notice inviting tender dated 28/11/2024, issued by the office of issued by the Samagra Shiksha Ahom, Alipara. Pusto. The case of the petitioner, Mr. K. Chaudhary, the learned counsel, senior counsel, appearing on behalf of the petitioner, submits that the petitioner have challenged the said notice inviting tender on 2 grounds. First, that the said notice inviting tender is not in conformity with clause 7.4 Roman 3 of the, what is FMP?
FMP looks.
Financial Management Procurement 2018. And as such, which mandates that there should be decentralization in the procurement of school uniform. The learned senior counsel has referred to the judgment of the coordinate bench of this court in the case dated 13/12/2019 in WPC number 1984/2019. The learned senior counsel further submitted that in the instant case, the goods which are sought to be procured by way of the impugned tender are goods which are available in the GEM2 small or E2 small M2 down portal. And as such, in terms with the notification, in terms with the office memorandum of the finance department dated 8/1/2024, which have been issued in terms with the provisions of the Assam Public Procurement Act 2017 have been violated. The learned senior counsel further submitted that in the instant case, as the goods are available in the GEM portal, the respondent authorities could not have gone into the e-tenders, e-procurement through the Assam tender portal. This court have also heard Mr. D. Soikia, the learned advocate general, appearing on behalf of the state of Assam. The learned advocate general submits that the judgment passed by the coordinate bench of this court in WPC number dated 13/12/2019 in WPC number 1984/2019 cannot be made applicable to the facts of the instant case, in as much as the judgment so passed therein. The judgment so passed, the judgment dated 13/12/2019 was rendered in the facts where the central government had funded the scheme, funded the procurement. So the learned Advocate General during the course of the hearing has placed an instruction issued by the Mission Director, Samagra Shiksha Home, wherein the financial sanction to the amount by the of the education bracket secondary department of the government of Assam have been enclosed. The above, the learned Advocate General submitted from the above, it would be seen that the procurement so sought to be made is a procurement by the state. And as such, the application of clause 7.4 bracket Roman 3 of the FMP cannot be made applicable. And so as also the judgment dated 13/12/2019 passed by the coordinate bench of this court. The learned counsel, Advocate General, further submitted that prior to initiation of the tender process, this court have the education department have also taken the clearance for the finance department, taking into account that the goods in question, all the goods in question are not available in the GM portal. And in that regard, the finance department has also given an approval, as could be seen in the as could be seen in the E5 number 573333. The learned Advocate General submitted that all these aspects of the matter would be duly placed by filing an affidavit. It has been further submitted by the learned Advocate General that the final date of the tender have already closed yesterday to deliver. And on account of an interim order being passed, the bids have not been opened. He submits that delay in the procurement of the tender would have an impact upon the students, and as such, the interim order is required to be vacated. Is not to be extended further. This court have duly taken note of the submissions so made by the learned senior counsel appearing on behalf of the petitioner as well as the Advocate General, learned Advocate General of the state of Assam. From the submissions so made by the learned counsel senior counsel appearing on behalf of the petitioner, more particularly in respect to clause 7.4 Roman 3 is of the FMP, it is the prima facie opinion of this court that the same shall not apply to the facts of the instant case, taking into account that the procurement which is sought to be made is with the funds of the state government. This court further is also of the opinion that the state government having already obtained the the education department having already obtained the financial clearance from the finance department on the ground that all the materials which is sought to be purchased is not available in the GM portal. This court finds no infirmity in going ahead with the e-procurement through the Assam portal. Under such circumstances, it is the opinion of this court that the question of extending the interim order passed by this court dated 18/12/2024 does not arise. The respondent shall bring on record their stand by filing an affidavit on or before the next date. Oh, the instruction is kept on record and marked with the letter X.
Highly obliged.
Subsequent result of
What?
and then
What
subsequent
are you
result.
going to do after sale, purchase, everything done? Would have otherwise put it. You want it, consolation. After dictating all these things, nothing remains also. You only want to keep the tail, we say. The tail remain wagging.
No, But the ground for appeal will become that they have not got the opportunity to look into our materials. That is why I want to
It's
finally-
okay.
that ground I am trying to avoid. Highly obliged.
The intent will be- No, that I will not pass. Not given it, nothing.
Item 4.
Lordship had the occasion to deal with this earlier. On the earlier occasion, suddenly a set of instructions were placed. That is why we had withdrawn with the liberty to file a query. And that
Oh,
is
this
how,
one.
it's on a very minor technicality that my application has been rejected. May I place the facts? Please? These oil companies, they have this concept called, they call it COCO, company owned and company operated outlets, where they appoint service provider. There is a reservation for ex-servicemen. And for that, the relevant guidelines are like this, my lord. If your lordship will kindly turn to page 31 first.
Oh, I remember their cases to the effect that you have not been routed properly.
Exact. That is a very minor technicality. Now we have amended,
Now, have you been routed? Have your application been routed properly now?
no one. That is why we are,
But they have to apply their DGR, madam. From there, we are seeking application from the DGR, madam.
but that again, your lordship will kindly come to their own.
That is
Sir,
the advisory, madam.
sir,
Name
this
has
is,
to be-
this is stretching it a little too far.
But the
Approval by
question
DGR
is, have
directly,
you,
madam, not
have
from the
you,
RSP or
have you granted anybody? No, na?
No, but the interview is to be held on 27 for one particular person, madam.
Only one person.
Your lordship will
They have
kindly come to
recommended
their
one
own
person.
circular.
Hmm. No, but if you are, because there was some decision taken later on. Because
Yes, no,
of the-
18/9 to 24, madam. The guideline has been issued on 15/12 to 23, madam.
Hmm.
And 26/6 to 24, madam. One name is sponsored by the madam, Razik Soinik Board, madam. And thereafter, we have received one communication from the DCR, madam, that the all of selection to be cancelled in view of the advisory, madam. That the name should be directly sponsored from DCR directly, madam, not from the RSB or JSB.
Then,
That's why, madam, we have cancelled the earlier interview, madam. Now the fresh interview has to be taken on, madam, on 27. madam.
Your lordship will kindly come to page 82. This was the document placed before your lordship on the last occasion. And your lordship will kindly see the language. If there is any application before the Rajya Sainik Board, that has to be forwarded to the DGR. It nowhere says that I have to run around, madam. How can it be? This is for the benefit of a particular section of
it's
Excel.
again for the DGR. You.
Your lordship will have a look at page 82. The only technical problem they have,
Page-
page 82. Their only problem is that
You was sent by the RSB.
RSB. That is the only technical issue. Now, it is their duty, if there is some application before the RSB, this itself indicates that it has to be
Can
sent
you
to the.
make the RSB a party? RSB
Yes,
a
yes,
party?
yes.
Are you seeking a writ from them?
Yes,
Where's the writ on
either let them
directing the
send it or-
respondents to report? No. Where's your direction you are asking that I should direct these people, that they should forward it if they have not done it?
Paragraph, prayer
Huh?
D, madam,
D.
page 26.
More respond to forward the petitioner's nomination for so and so. Who is respond number 6 and 7?
6 is, my lord, the Director Sainik Board, which was formerly known as Rajya Sainik Board, RSB. Now it is known as Directorate of Sainik Welfare.
And DSB. Okay, so you are asking them, na?
So let them forward it to the DGR. madam.
His application is pending.
Yes,
No, it is cancelled, madam.
well, they have, on this ground, they have rejected. That is what we have.
No, we have rejected.
That because of the fact that his application
You have the
was
advisory,
not
madam. Yes, madam.
processed properly.
Yes, madam.
But the fact remains out here that his application was filed before the arrest. He filed his application before the arrest. What happened is the RSB directly sent to you.
Yes, madam. That's right,
The
madam.
RSB should have sent it to the DGR. Without sending it to the DGR, when it's sent to you, you have rejected him.
Yes.
But the fact that he has also submitted an application. His application is also required to be considered, but if routed through the DGR,
Then
No,
we can say, madam,
no, understood, you cannot say. But the DGR is not doing it.
but the-
Because of the fault of the DGR, his right to be considered, which is also a fundamental right, is being taken away.
kindly say by 84, madam, page 84, but the advisory note, clause 4, madam. Earlier, madam, the one person can apply for 2 or 3, madam, the location, madam. Now, this has been, madam, the limited to one location only, madam.
That
Then-
will- that will be a consideration on merit.
Page 84, clause 4, madam, kindly see, madam. 4 and 5, madam.
DGR communicated to the OMC that henceforth nomination for the DGR sponsors shall be advised by DGR Delhi itself, and nomination received from the RSB should not be considered. Rightly.
Yes, madam. Now, clause,
Then?
5, madam. kindly see.
Huh?
5.
Ah.
5, 6 and 7, madam. These are in
Benefit of all welfare schemes to the servicemen are to be provided only once. Then,
and 7, madam. Next page, madam.
Huh?
7, madam. Clause 7, madam.
is 7.
Yes, madam.
Okay.
Why, madam, it was,
Some
the
cases
selection
where
was-
we have advised the OMC not to consider the nomination sent. OMC has observed that the applicant for whom nomination is prior to issuance of the advice. Since the applicant have been well benefited. Has he already a benefit?
page, kindly see page, madam.
No, Mr. Bhattakur, has he already got any benefit?
No.
Then why you are referring to all this?
No, madam, he was called for interview, madam, in the midst of the selection procedure, madam, the process was cancelled, madam.
Because of the fact that
Yes,
it
madam.
was through the
Yes,
RSB.
madam. In view of that, this.
It is not his fault. He filed it to the RSB. From RSB, it has to go to the DGR. DGR is sleeping over the matter. So under such circumstances, if you just only consider the other person,
Yes, sir. 27.
because there the RSB rightly sent it to the DGR, and from the DGR it goes to you, and not him, wouldn't that be a violation? Anyway, that respondent is there or not?
We are not even, we have come to know just now that
Yeah,
some application is being considered. Because they,
6 and 7. RSB.
Yes, madam.
Why you are, you are the main person who is causing all the problems? And his meeting is when?
27.
27, we have to state. But we have to make this, no further things be carried out, we'll pass it, but you have to make them your party.
we are not even aware of, we just came to know. Because they are not doing it transparently. Who is the person who has been called? Nothing.
And I am providing.
You
we'll-
go home, see in the YouTube, he has referred to a name, find it out, the address, and then put him. But Mr. Naik, if you notice making it returnable on. How much time? You send that in the meantime, his application has now, what happened? You have returned the application to him.
So it was cancelled, madam.
Understood. What happened then? Have you again filed another application?
No. But
No. We are,
You should have returned it then.
he has to apply in the DGR but directly, madam. From there, madam, the name has to be sponsors to the.
Where is that? Show me that. Then only,
Yes, madam.
where
Can
is
you see,
it?
madam,
That
the-
he has to apply directly
Yes,
to them, not the RSB.
As to how, madam, we,
page 82 makes it clear.
46, madam.
Huh?
46, sorry, madam.
Yeah.
Page 46, madam.
Eight?
46 is the guidelines, madam.
He has to apply to the DGR only.
Yes, madam.
Yeah.
Earlier, madam, at the signing board, madam, from there, madam, we are seeking, madam, nomination.
Another will be approached for seeking nomination of so and so.
Yes, madam. Earlier, madam,
Of
we
the
are seeking
area.
nomination from the
DGR so and
signing
so
board,
will
madam.
be requested to respond within 30 days of so and so. Director so and so would be the nodal office for sending the
officers, madam.
nomination. So director will send the
Yes,
nomination,
madam. Yeah,
but the filing of the application will be where?
But he has to apply in the DGML directly, madam, from there.
No, it is not mentioned there.
But it mentioned that, but we are seeking nomination from the Rising Soil Board, my lord. Earlier, my lord. Now it has to be, we are seeking nomination from the Director General, my lord. DGR, my lord, directly, my lord. Then this name has to be sponsored by DGR directly, my lord. Earlier, my lord, Rising Soil Board sponsored the name, my lord, directly, my lord. Now this situation has been, my lord, since, my lord. So the fact that, my lord, now the applicant, the petitioner has to submit a affidavit for the DGR that he will not apply for.
Yes, tell me.
Because the clause 5 on that. Clause 6, 5 of the advisory, madam.
Okay,
Yeah,
that's fine. You should notice making it returnable on 21/2025. 23. 23 Thursday. 24/1/2025. Mr. S. Bhattakur appears on behalf of the respondent number 1 and 2. Mr. No, wait. Mr. S.S. Roy appears for the respondent number 3, 4, and 5. The A. Fukon appears for the respondent number 6 and 7. Now tell me, if you are so much of a standing counsel, whom should he submit the document? Then you are newly engaged. You can't be a standing counsel and not know all these things.
The clause 5.
As all the respondents are duly represented, extra copies of the petition be served upon them during the course of the day. The case of the petitioner, as could be seen from the records, is that was sponsored by the respondent number 6 and 7 to the respondent number 1 and 2 for selection of service provider for cocoa. However, the petitioner's application was rejected, taking into account an advisory issued by the page
82 basically,
advisory issued
by the Ministry of Defense.
by the
Page 82, Ministry of Defense.
No, by the Lieutenant, by the Ministry of Defense dated 5/4/2024, which stipulates that the recommendation has to be made from the DGR and not through the RSB/JSB. Full stop. The learning senior counsel submitted that in pursuance thereto, the petitioner had filed a writ petition. However, the said was withdrawn, taking into account that the said policy was produced during the course of the hearing. The learning senior counsel submits that in pursuance thereto, the petitioner was awaiting that the respondent authorities shall return the proposal so submitted by the JSB.
Or alternatively, RSB would send it to the DGR. So
To the JSB, to the respondent number 6 and 7, respondent number 1 would send the proposal which was recommendation which was submitted by the RSB, respondent number 6 and 7. Then senior counsel submitted that the petitioner was awaiting that the respondent number 1 and 2 shall again return the recommendation of the petitioner to the respondent number 6 and 7 to be sent through the DGR. However, nothing has been done, and the petitioner has now come to learn that there is a move for handing over to select some other person, thereby depriving the right of the petitioner to be considered, which is in violation to Articles 14 and 16 of the Constitution. This court, in view of the submission, had inquired with the counsel appearing on behalf of the respondent numbers 3, 4, 5, as well as the respondent number 6 and 7 as to whom the petitioner was required to submit the application. So the councils, so the state's council appearing on behalf of the respondent number 3 to 7 submits that they would like to take instructions. So, taking into account the above, this court is of the opinion that some interim protection is required pending disposal of the petition, inasmuch as it is apprehended by the petitioner that the respondent number 1 and 2 would issue allotment,
Order of appointment.
order of appointment. In that view of the matter, this court, for the ends of justice, directs the respondent number 1 and 2 shall not which area? Means particular area?
Is Sriram.
Here he is for which one? This cocoa is for where?
Srirampur, Kokrajhar.
And the other person is for Srinampur.
No, the location of this petrol pump is at Srirampur.
This is specifically for cocoa.
Yes.
Where do I get it?
Malad will kindly come to the first direction. Letter. The subject matter, later, madam. Letter.
No, I
Page 76.
shall not finalize the selection process in respect to cocoa service provider at BP Srirampur District, Kokrajhar. In the next. The respondent shall bring on record they stand by filing the affidavit. Yes? To say submits that the affidavit would be filed during the course of the day, taking into account the above. This matter again on 8th of January 2025. Wait. He did it for the purpose of urgent some necessity. Do you have some similar circumstances?
Your Lordship, the urgency is basically the matter is led by senior counsel D. Saikia. And
Who?
Senior advocate D. Saikia.
Ah.
So Lordship, he's not available right now for the.
So what? I don't grant adjournments for senior counsels. That is when the matter is.
In my matter, there is an interim order, it may kindly be extended.
What interim order?
Regarding an NIT, the operation of which has been stayed.
Hey. My goodness.
Even 7 melody on the hearing, 7 melody can be hidden.
No. I don't extend interim order. Without a most notice being issued, I don't extend.
It's an admission matter, Lord.
Admission matter.
Yes,
Okay.
there is already an interim.
It's an admission matter.
Yes.
The interim order passed the list.
Obliging.
Item 5.
But here in this case, the non-payment of supply bills, madam. And yesterday, madam, the similar case, your lordship has issued notice, madam, by fixing the matter on 12/2.
The issue notice making it returnable on when?
12, February 12.
2024. 25. So Goswami, you are paying for?
Yes, 1, 4, and 5.
Additional advocate general appeals on behalf of respondent number 5. And none for the revenue. None appears on behalf of the revenue department on call. Mr. So-and-so appearing on behalf of the petitioner submits that the revenue department of the government of Assam has the standing counsel. Taking into account the above. For If Mr. A. B. Gusami accepts notice on behalf of the respondent number 1, 4, and 5, extra copies of the petition be served upon him. Course of the day. With regard to respondent number 2 and 3, extra copies be served upon Mr. Arbol Pujari, who is the standing counsel of the Revenue Department. The case of the petitioner herein is that petitioner is entitled to an amount of rupees 1,88,60,094 on account of certain supplies being made. It is in view of, however, it is the case of the petitioner that no payment of the amount have not been paid to the petitioner. And it is under such circumstances the present petition has been filed. The respondents are directed to bring on record their stand by filing the affidavit. before the next-
Items 6, 7, and 25 is same. Only amount is different.
Like,
Fine.
Item 8.
Taking an annexer of this petition, I may
What?
be allowed to withdraw this petition with liberty to file a fresh one, Lordship.
Why? What
Lordship,
happened?
There is a mistake in this petition,
Huh?
annexing an annexer, Lordship.
You have not enclosed an annexure.
We enclose but wrongly another,
Too many cases. The
Lordship, I
counsel
will be
appearing on
allowed-
behalf of the petitioner submits that she wants to withdraw the instant writ petition, taking into account that there are certain formal defects. He further submits that she may be permitted to refile by removing those formal defects, taking into account about used on withdrawal. Liberty, however, is given to the petitioner to refile by removing those formal.
Item 9.
This
Also, regarding non-payment of bills, your lordship,
on payment,
Nirmahasa, your lordship,
how much? 53 lakhs.
your lordship, I am agree that, after issuance of NIT, your lordship, I have been issued supply order, then I have supplied all the items as per the supply order, they have received it, and then I have raised the bill, and they have not paid the bill. Finding the alternative, I have filed a representation, your lordship, and in reply to the representation, your lordship, they have given a letter, that is important, your lordship,
Where?
page 40. To number 1 is the petitioner, your lordship, subject release of bill. So, with reference to the above subject, I am to state that your bills under SOP this scheme for the year 2024-25 could not be passed to council due to the fact that the undersigned is in receipt of letters from the NCL's Autonomous Council regarding cancellation of administrative approval accorded under SOPD so and recasting of annual action plan for the year 2024-25 and submission of fresh proposals for accord of administrative approval. Now, before issuance of NIT, it is mandatory that the SOPD fund, whichever is received from the state government by the council, and administrative approval is required. And that is given by the planning board. The chief executive member of the council is the chairman of the planning board. Now, after this administrative approval is accorded in the annual action plan, the annual action plan, the administrative approval of annual action plan is accorded. Thereafter, the NIT is issued. So now, along with this letter, they have annexed another letter, which is at page 41. This is the letter given by the principal secretary to the chief executive member from the principal secretary to the additional director of agriculture. I'm reading it out, your lordship. With reference to the subject cited above, I have been directed to bring to your kind information that the administrative approval against the budgeted fund under SOPD for the year so-and-so has been accorded and issued without obtaining any approval from the Honorable CM, and hence the administrative approval issued is to be termed as invalid. So the basic reason why the administrative approval is invalid, according to them, is there is no approval from the CM. Now I'll take your lordship to page 42, the next page. This is the annual action plan for the year 2024-25, and below it submitted by the district agriculture officer. Page 43, the items which I have supplied. Page 44, approved, the word approved is there, just below the table, your lordship will find. And the chairman DPD and chief executive, he has signed it. So he has approved it. Now the letter at page 41 is nothing but a blatant lie, your lordship. He has approved it, I have shown your lordship. And now they have said that since he has not approved, that is why the funds will be
Notice
diverted.
making it returnable on 2025. The Ishama accepts notice on behalf of the respondent number 2, 3,
Yes, lordship.
2, 3, 4, 5, 6. 12. Of respondent number 1, queryable. As all the respondents are duly represented, copies of the petition be served upon them during the course of the day. It is the case of the petitioner that pursuant to a work order being issued, pursuant to a tender process,
Tender process.
work order was issued to the petitioner. The petitioner duly completed all the works, and as for the petitioner, entitled to an amount of rupees 53,38,876. However, the respondent authorities have rejected the bills of the petitioner on the ground of rejected the petitioner illegally on the ground that there was no sanction from the chief executive officer, which however is incorrect, taking into account that in the annual action plan SOPD for the year 2024-25, the chief executive officer has approved. A member, the Mahasa Autonomous Council, Haflong, had approved the same. The respondents are directed to bring on record their stand by filing their affidavits on or before the next day.
If I have an interim period, this may be stayed. Otherwise, the fund will be diverted, your lordship. This
What's
is
stayed?
SOPD fund, the only fund for the council, your lordship.
The entitled,
At least this, so that the fund cannot, otherwise.
you are entitled, you will get the money. If you are not entitled, we cannot. He doesn't have any head or tail knowledge about what is happening.
Of course, your lordship. He will not.
Let us find out. Why should
Item
be
10.
stayed? The question of money is not to be stayed.
Lordship, but date may be fixed for that.
I fixed it. 14 to.
I'm sorry. Oblige, your lordship. Grateful, your lordship.
Yes, Mr. Bibi Bora. What is this?
Is against the transfer of holding number and with disconnection of my electricity without notice and without.
Who has done that?
Bukazan Municipal Board, Lordship, it's
Bukazan?
40. It's Lordship SDO, but firstly, the holding number was transferred at page 39 without any notice. What has happened, Joginder Sharma, that is my late father, had 2 wives and 9 children.
Who are you? Yes, then.
Lordship would
Two
find my
wives
family
and
tree
8
at
children. 2 wives and
9 children.
9 children. Okay,
A
then.
family tree at page 16.
Okay, then.
Therefore, Lordship, at page 39, firstly, the next of kin was obtained by the my stepmother.
Hmm.
Thereafter, the holding number was transferred. Because of the holding number being transferred, the electricity was disconnected.
Who?
The Lordship, we have given a
Who is
representation at page
disconnected?
40.
Who has
SD
disconnected?
Lordship, we have not been furnished any reasons.
No, who has disconnected? They can.
Lordship,
Who
we
has
have,
disconnected?
No instructions that are passed.
What is this?
The disconnection was carried out at the
Oh,
request of the consumer.
so kindly disconnect permanently the meter with consumer number in my building as I am unable to.
Secondly, my lords, the next page thereafter, my lords will see
they've already applied for a new connection. It has been granted to them, my lord. That fact has been suppressed, my lord.
No, not suppressed. I don't know. I don't, this was, really, I have to take instruction on
this was
this.
done
I
in
never
October.
suppress anything. Lordship, I never
New
suppress.
connection, no instruction.
No
Your name is
instruction.
what?
Their
Your name is Anand Singh.
Anand Singh.
Okay, Happy Singh. So therefore, you have already paid a new connection and connection has been given.
Yes, ma'am.
So then nothing remains. The petitioner herein is aggrieved by the disconnection made, the disconnection of the electricity disconnection of the power pertaining to consumer number 161560100600271 by the APDCL authorities. And it is under such circumstances that the instant writ petition has been filed. Mr. B. Chaudhary, appearing on behalf of the APDCL authority, submits that the instant writ petition suffers from suppression of material facts, inasmuch as it has not mentioned that the said disconnection was made at the request of one Santi Devi,
29.
who is the wife of the father of the petitioner. Be that as it may, the learned counsel further submits the petitioner thereupon has applied for a fresh connection,
Temporary connection.
fresh temporary connection on 20/12/2024.
That was on 29/10/2000.
Huh?
29/10/2024. 2012 is
29/10/2024 by making a payment of rupees 12,200.
yes.
Full stop. It has been further submitted that a fresh connection thereupon has also been given to the petitioner pertaining to consumer number 1560100748283. Full stop. Mr. B.P. Bora, the learned counsel, appearing on behalf of the petitioner, submits that he have not been informed about this development. And as such, it's full stop. Taking into account that the petitioner now has a connection with a consumer number as stated herein above, nothing further remains in the writ petition for which the writ petition
Full
stands.
prayer is there. One is connection, one is transfer of holding number also.
What we are
Prayer is
doing with the holding number?
Page
Why
39.
should we look into those?
Page 39. Lordship.
Why you are bringing all of the, why not tomorrow file a civil suit also here? What is this? So many connections?
Lordship,
10/7/2024, where is that? Order?
Lordship, page 39. Lordship, in that prayer issue, notice may be issued.
Transfer, this is to certify that the authority of so and so has pleased to accord transfer of so and so to Santi Devi. This is to certify that the old holding number is there. Now, against the chairman, Bukazan Municipal Board, what do you do? An appeal lies.
So I'll file appeal.
Full stop. Mr. B.P. Bora, the learned counsel, appearing on behalf of the petitioner, further submits that the petitioner have also assailed the order dated 7/10/2024 issued by the chairman, Bukazan Municipal Board. Full stop. It is the opinion of this court that the petitioner has an alternative and an efficacious appellate remedy. And as such, the question of entertaining a writ petition to a challenge to the transfer of the holding cannot be made. Accordingly, the instant writ petition stands closed. However, the petitioner would be at liberty to avail such alternative remedy as is available under the Assam Municipal Act 1956. The document submitted by Mr. B. Chaudhary is kept on record and marked with the letter X.
Item 11.
Yes, what is this?
This what matter pertains to Fatemabad Tea Estate. There was a huge amount of default by the owners. Ultimately, the authorities invoked the powers under section 15(1)(c) and appointed a receiver. Originally, someone else was appointed. He gave up. That is when I was brought into the scene, my lord. Your lordship will find the.
You are the receiver?
Yes,
You are the receiver? Okay, then.
my lord. We will kindly come to page 33, the agreement. Page 35, it starts. Your lordship will kindly note the date, 22nd day of December. And if your lordship kindly turns to page 37,
This agreement is between Swan Joint or Sangmai? Who is
One.
it?
Additional PF commissioner,
They make you the,
basically to manage the
Receiver.
affairs of the garden.
okay. But
And
they have taken action under that, this act, Provident Fund Act.
my lord, if your
And-
lordship will kindly turn to page 37, in the middle of the page, whereas the second, has my lord got it? Whereas the second party has already deposited 38 lakhs, etc., against the cess of Greenleaf charges for the year 2020 as agreed in the earlier agreement dated so and so. Furthermore, the second party had deposited an amount of 20 lakhs on so and so date through RTGS, etc., and thereafter another amount of 20 lakhs and so on. And I continued to make these deposits even before this agreement was made. And based on that, page 38, clause 2, that the term of this agreement is initially for a period of 3 years with effect from 1/1/22, subject to renewal for such period and on such terms and conditions to be mutually agreed. So based on this agreement, my lord, over a period of time, not only have I been clearing the dues, I have made huge amounts of investments which I have annexed. My lord, I am not troubling your lordship at this stage. That up to the extent of 39 crores. But I have been telling them that my term is coming to an end. If your lordship will kindly turn to page 57.
Now tell me, you can invest. Where is that in the agreement? Where is it in the agreement that you can invest to the tune of 39 crores?
But that was what was given. If your
No,
lordship peruses various aspects, I have to, well, I have to manage the entire, the garden was absolutely in.
whatever
But-
may be.
but I'm not even on that.
Chaudhary, this
I'm not
term
on
is
that.
never given out there either. Yeah, tell me.
Well, I'm not on that, Mal.
Ah.
What I told them is,
Ah.
it's very simple, page 57. I said that you appoint an auditor and have the accounts audited, clear the account, because my term is coming to an end. Now, they appointed an auditor, and thereafter, as recently, I've been continuously representing that you take a call, either because there is
Kindly see 18,
89.
page 41, page 41.
That is
Paragraph, clause 18.
yes, ma'am. That if the
Mhm.
first party wishes to liquidate the Fatemabad Tea Estate by auction or any other arrangement, the investments made by the second party or his sister concerns to uplift the tea should be treated as secure creditor similar to that. All those things are there, ma'am. I'm not on that at
No,
this
no,
stage.
no. So your interest will be like that of a secured creditor. So far against the tea garden.
But-
Not against these people.
Ma'am.
Then,
Now, I told them by page 57
Mm.
that my term is coming to an end, 3 years, which will come to an end on 31st of December, my lord. Page 57. With reference to the subject cited above, we humbly beg to request your good self to make necessary arrangements for auditing the accounts which were submitted by us on so and so, so and so. Thereafter, they did appoint, and I submitted a representation as recently as on 18/9/24. If your lordship kindly turns to that next page, ma'am, page 58. It's the longest representation. If your lordship will kindly come to page 59,
then,
right at the bottom, ma'am. This is to further inform you that the undersigned has written several letters dated 11/1/22, 17/6, etc., etc., for appointing the auditor to ascertain my total investment in the garden, and in return, your department has appointed auditor by so and so, dated so and so, to ascertain the income and expenditure account of Fatemabad Tea Estate with effect from so and so. But due to some personal problem in his family, the CA was unable to submit his report despite all auditing at our office and garden. And after that, another auditor was appointed by the department,
And second one also done the complete auditing in our office as well as in the garden, and the final report is still awaiting. So thereafter, in couple of regular discussion in your office, the undersigned has come to know that the director of so-and-so industries is keen to take over the garden on expiry of our term, that is 31/12/24. In this connection, we beg to inform you that we have also audited our books of accounts with effect from 4/1 so-and-so to 31/8/24. The original report is enclosed herewith for your ready reference.
Now, what are you challenging?
Now, well, they are neither taking any call on that clause two for extension, nor are they settling my accounts.
No, they have already rejected it. This is, you have been issued a notice on 19/12/2024 saying that you have to pay 8 crores 59 lakhs, which you have not default paid.
So
Where is the
this is
question
not
of
to-
granting you an extension?
This is not to acknowledgement.
They gave it only yesterday.
Yes.
That is why they say that we are not extending. What to do?
Well,
Here, Lordship, extension is not a prayer here. Neither renewal of the contract is a prayer here. Here only the first prayer, Lordship, it goes through, Lordship. It is only a prayer for completing the audit for the year 1/1/22 till 24, Lordship. That we have already done, and it is clear from the letter dated 19/12/2024, Lord.
What is the final settlement of accounts? You have no right. That is what I said about clause 18. Clause 18 says that you will be a secured creditor of the garden. Then tomorrow, when the garden goes for liquidation, you will be very well be a part of it. It belongs to some tea garden,
that is
estate, the company.
well,
You have 39 crores, go there. That is that code, NCL.
but this was not to our knowledge. That is why we had to come to the court.
Okay, give me a copy.
Okay, I have one copy on that.
But perhaps the moment they got the copy of the writ petition, they decided to do this. We are totally,
But the fact remains out here that apart from the above regarding payment of your legitimate dues, we have conducted an internal audit through Deepak Agarwal and AF for the period from 1/1/2022 to 31/3/2000. And as per the said audit report, the amount payable to you have been calculated at 8 crores 59 so and so. As such, the amount you have claimed by your referred letters is in the consideration of the above fact, it is appears that you have miserably failed to run the garden as per the terms and conditions. We have also rejected your request for continuation of the possession of the area with your after the expiry until final settlement of the account, as you have no legal right to continue with the possession of the beyond so and so. And also for the reason that any such decision may further aggravate the workers' unrest. Yeah.
আৰু আমি পাব লগা আছে। সেইবোৰতো তুমি dispute কৰিব লাগিব চোন।
Challenge this type of thing.
In view of this, Malad, obviously,
Mr. Chaudhary, every time your matter comes up before
Stop.
me, the first thing is that you have to withdraw with liver to.
and always something new is,
Yes. Okay, Mr.
this was probably after they got a copy of the writ petition. We filed it yesterday, and this is also dated yesterday. We filed it day before.
I Chaudhary, the learned senior counsel assisted by so and so submits that in view of the communication dated 19/12/2024 issued by the respondent number.
This is
Number 2, 3,
Board of
and
Trustees.
4. 2 and 3. Respondent number 2, na?
3 and 4, Lord.
Where is this? You have not made them a party? All the employees provident fund organized?
Yes, it's a party, Lord.
Huh? No.
Secretary come PF commissioner.
How can a secretary be a party? The organization is to be made a party.
Organization as a whole.
That appears to be.
Appearing on submits that in view of the communication issued by the Board of Trustees of the Assam Employees Provident Fund Organization dated 19/12/2024. And which is subsequent to the filing of the instant writ petition, the petitioner would not like to press the instant writ petition. but seeks the liberty to seeks the liberty to challenge the said communication dated 19/12/2024, keeping his rights, keeping the cause of action mentioned in the instant writ petition alive. So, taking into account the above, the instant writ petition stands closed on withdrawal, the petitioner is given the liberty to challenge the communication dated 19/12/2024, along with the along with keeping the cause of action for the present writ petition alive.
I'm appealing for 2, 3, and 4.
P9 appears on behalf of the respondent number 2, 3, and 4, and Ms. Esbol appears for respondent number 1,
5, and 6.
1, 5, and 6.
Well. Wait, please, Your Lordship.
Yes.
My lord, a contract for civil construction was awarded to the petitioner, my lord, by the Indian Air Force, that is at Mohanabari Airport. Now, the work also involves steel structural construction, my lord. And there is a particular clause in the agreement, which your lordship will find at page 29. The steel which is to be used in the construction, it has to be procured from a particular source only. Serial 4, my lord. Structural steel, as a lordship got it at page 29. Structural steel.
Mr. Chaudhary, I'm younger to you, but then also I have difficulty in reading it.
Yeah.
Absolutely not legible.
I'm sorry, my lord. Yes.
Yes, much better.
Structural steel shall be procured by the contractor from approved primary manufacturer of steel like Rashtriya Ispat Nigam Limited, Visakhapatnam, Tata Iron and Steel, TISCO or Tata Steel, Mumbai, Steel Authority of India, Delhi or MS Jindal, Steel and Power, Gurgaon. So we are to, my lord, procure the steel from these particular sources only. Now, my lord, regarding the availability of the steel, I took up the matter with SAIL at page 33, my lord.
And kindly read note 1. Any other manufacturers approved by EIC branch,
Yes.
New Delhi. But
Any other manufacturer approved by, yes, engineer in charge branch, New Delhi, but left out in the above, it shall also be deemed to be, yes. But our case is, first we wrote to the Shillong office, my lord. Shillong office in turn, sought permission from the CNC, till that this permission has not been given. So therefore, my lord, naturally my work progress is slow. Now what had happened, if your lordship kindly comes to page 51, now those communications are there. If your lordship should kindly come to page 51. Now this is the workload return of contractors class D to S and unlisted contractor, etc., etc. Now, my lord will kindly come to page 53. Page 53. Here again, my lord, the same issue. We have typed out the copy. Please come to serial number 50, my lord. Garg brothers, the remark against me is slow progress. Now, my lord, the system is such, whenever, my lord, this endorsement of slow progress is there, my lord, then, my lord, I will not be permitted to take part in any other tender. And my technical bid will be rejected. Now, my lord, at page 60 and 61, in respect of two works, my technical bid has been rejected. And that is why we are before your lordship.
Well, it has been rejected.
Yes, my lord, page 60. You are informed that your bid for the above tender has been rejected during technical evaluation by duly constituted committee for reason not eligible due to slow progress. Similarly, my lord, at page 61, in respect of another work, my lord, because of the same, it has been rejected. My lord, what do? I was sent to the dealer do not have this stock. I went to the specified agencies, they do not. Actually, my lord, basically, here a small quantity of steel is required. And one of the designated authorities said, we don't supply such small quantity. Then eventually we have to take permission. We sought for permission. Shillong office forwarded it to my lord. That later lordship will get. Yes,
Page. you
page
refer to
49, my lord.
49, no?
Page 49. This is a communication by the garrison engineer, who is the primary authority. Now kindly see, my lord, he is writing to Commander of Works Engineer at Jorhat. The para 3. Office has also inquired the above facts through email by contractor and found that NSC submitted is genuine, non-availability certificate. In view of above, it is recommended that necessary direction may please be given for procurement of structural steel from authorized distributor of sale, that is Sagar Roofing Private Limited, as requested by the contractor. Now, my lord, this permission, they are sitting over. And then, my lord, at page 50, Jorhat office forwarded it to Shillong on 24th of October 24. That is headquarter, chief engineer so-and-so. Para 3, in view of above, it is recommended that necessary direction may please be given for procurement of structural steel from authorized distributor of sale, that is Sagar Roofing Private Limited, as requested by the contractor and as recommended by the garrison. Now these are all pending, my lord, nothing has progressed. Then, my lord, I have
Page 54.
and page 54, my representations are pending. It was on 24/11/24. Well, it is not my fault, my lord. So at least this.
Now
slow
what do you
progress-
want?
My lord, my limited prayer at this stage is, my lord, that remark that slow progress has to be stayed. Otherwise, my lord, every time I apply for a work, this will happen.
No, at that stage, it is not possible. Let them put them to notice and we ask them to file their affidavit.
Yes.
We finish it off as early as possible. That is the only way out, because
Lordship,
without
my
hearing them,
instruction
it
is
would
that,
not be proper.
Lordship, my instruction is this slow progress, up-to-date status in the month of November, it was of
December.
December, it has been withdrawn.
Huh?
Now it has come to weekly progress, they say, Lordship. Now there was no slow progress. Remark is there, Lordship. In the-
That can be recorded and petition can be closed.
For the month of December, the report has come that slow progress is not there, Lordship.
Get your
Remark for-
instruction, we are sitting till 4 o'clock, we can close.
Lordship,
If that is there, nothing remains.
Yes, yes, if that is there,
it is of October.
This is of October, but your decision is of 2nd of December.
And this-
Kindly
Lordship,
see
these
page
are the-
60. No,
these are the
Mr.
tender
Roy,
process.
Mr. Roy, kindly say page 60.
Page
Annexure Y.
60.
Lordship,
This is of 2nd of December.
This is the tender process already over, Lordship.
Understood. Now the question is, do you still have his problem with the slow
slow progress.
For
That's the
ma-
question.
In that tender process, that I have to take.
But that is okay. We are not
No, no,
concerned.
this
with
is gone,
that.
my lord. This now I cannot be right.
That is gone, but we are only concerned that he is only concerned that because of the slow progress which you have remarked out there, now he is not in a position to compete with any
Participate.
That has
So,
been,
or participate, he cannot participate. So therefore, he is asking for stay. I am saying that, okay, we will ask you to file your reply and finish it up in the first week of January. This is second week of January. So this is what. But if you have that slow progress is not there,
Not
I
there,
don't think Mr. Chaudhary would.
I think that can be recorded and petition
Lordship-
can be closed, my lord.
let it be on the first week of, second week of January, because I don't have the written.
No, my lord.
communication.
Till then, my lord, then they will not cancel my tender on this ground, subject to further orders of this honorable.
No. I was not supposed to, because of you, get your instruction by 4 o'clock.
No, if my learned friend is
Only
really
for-
having that
get
instruction,
your-
that helps
That
me.
slow progress is not there, Lord.
And then
My
that can be
instruction is
recorded.
no progress
You
is
cannot
not
come
yet.
up with like this.
Lordship.
If you say that there is nothing, then obviously the question, nothing remains in the petition. Get your instruction by 4 o'clock as to whether there is any slow progress or not. You have
As
been
on date.
verbally informed. Ask them to send it to you by WhatsApp, we take it up. Finish it up. Procedure keeping this matter. Yeah.
Very well done. Deeply applied. F 22.
Yes. Mr.
Your
Chakravarti.
Lordship, my lord, non-payment of contractual dues, my lord, to the tune of 77 lakhs odd.
My lord, they have admitted their liability at page 24. But the reason for non-payment is not known, so let them come.
What scheme is this?
Scheme I don't know.
My lord, this is a scheme.
Scheme I
for-
don't know. Lordship.
You have not read your petition.
Sir, I have gone through it, but
Then it must be on the basis of some scheme. Is it anything to do with the central government? No.
No, no, my lord, here, this is in respect of
Okay,
this.
issue notice
flood.
making it returnable on
just
17/2/2025. Justice on my appears and accepts notice on behalf of the respondent number 1, 3, 4, 5, 6, 7. Did you see anywhere, Mr. P. Naik, I saw him, nah? Mr. P. Naik appears and accepts notice on behalf of the respondent number 2. Taking into account that all the respondents are duly represented, extra copies of the petition be served upon them during the course of the day. The petitioner herein is aggrieved by the non-payment of, is aggrieved by the inaction on the part of the respondent authorities in paying the amount of rupees 77,21,422, which have been duly admitted by them. Full stop. The respondents shall file their affidavit bringing on record their stand on or before the next stage.
Deeply applied.
23.
Yes, what is this?
Here in this matter, my lord, the petitioners before your lordship, in the petitioners before your lordship, in the year 2020, they have applied for IMFL on licenses. IMFL stands for Indian made, my lord, foreign liquor. In the meantime, my lord, cabinet decision was taken that all licenses will not be issued. Thereafter, my lord, the respondent authorities have stated, they have issued a notification that those pending applications, my lord,
Then
those applications, those were
what do you
pending.
want? This
But-
post should be the post office.
Similar set of petitions were
Similar is very
And-
good. The other courts are very kind enough. I don't want to be a
Yeah.
post
My
office.
lord, here, my lord, the case.
Submission of a representation, they have not taken into consideration what right you have.
We are praying for the. my
And
lord,
why everybody is come together?
My lord, I have stated because.
Every,
similar
means
constitution
all of them want one shop or everybody
Uh,
wants different shops?
Stated clearly, my lord.
No, madam, tell me,
I have separate port fee.
are you saying that all of them wants one shop or separate? Then
My lord,
misjoinder of necessary causes. Everybody has a different cause of action. You can't file this type of way. We are actually, I would understand for filing writ petitions for those persons. Those some teacher, they are not in a position to come. You are asking for an excise license, IMFL. What is that? Indian made fair and liquor. Yes, not possible.
my lord, we have.
This
prayed
type
for,
of writ
the-
petition should not be encouraged. The council appearing on behalf of the petitioner seeks for an accommodation, list this matter immediately after vacation. I will dismiss it to me.
24.
Some other judges are very kind, and I am a temporary to these type of benches.
Of laws, Lord.
Yes, what is this?
May I please, your lordship?
Oh, yes, what is it? What
Lordship,
do you want?
in 2014, lordship, I was having a firm which was running the work of laying optical cables for Reliance Communication. During that time, Lordship, I employed around 10 to 14 persons. So for that reason, Lordship, I had to take registration under the ESI Act, Lordship. After I faced loss, Lordship, then these people also left. I also stopped doing that work. I have moved into another business, this thing. Now, what has happened is, Lordship, is that in 2000, if Lordship comes to page number 61, I received a call from my bank that my account has been freezed because a prohibitory order has been passed. Page number 61, Lordship.
Then?
Because after Lordship put it.
How much amount?
From there, Lordship, I have come to know that there's a order under 45A has been passed against me in the ESI.
Now tell me, Mr. Counsel, you applied under the ESI,
Yes, Lordship.
your firm or whatever company or whatever may be fell within the ambit of the ESI.
Yes, Lordship.
After you closed your business,
Lordship.
did you inform the authorities that look here, I have stopped doing my business, I've closed down the firm, so kindly cancel my
I admit,
petition?
Lordship, I have admitted in my petition that that was an inadvertent mistake on my part that I didn't
No
inform the
case.
authorities, Lordship.
No
But
case.
what has happened is, Lordship, that there's no employees under me, Lordship.
So what?
In who's this,
So what? You were supposed to.
for whom would I
Why you
submit
are
a
not taking him to
contribution,
the
Lordship?
jail? Why you are not taking him to the jail? When you are asking him, taking action against him, it's a criminal offense also, isn't it? Non-payment of the ESI.
Take under section 1(6),
Yeah.
once an establishment comes under the act,
Yeah,
it will deem to be
that
continued
cannot
unless.
get away unless you deregister it.
Yes. In fact, the.
You want kinder judge? Counsel appearing on behalf of the petitioner submits fix for an accommodation, list this matter immediately after the questions.
And your place, Lordship.
26.
Yes, Mr. Mishra. What is this?
The tree board is not considering the application for subsidy, my lord. We have made
What?
application. There was a scheme, my lord, in the tree
Ah.
board. We applied into the scheme, my lord. Made application, that application are pending before the tree board, my lord.
So we should direct respond number 2 and respond number 3 to act in accordance with the provisions of that scheme.
Scheme. Please take notice, may go first.
Who appears? Union none. I saw Miss S. Borua somewhere moving around. And who are these? Oh, you are there, Mr. Odigari. You will be appearing for whom?
This case was resorted to someone else, my lord.
Hey, someone else must have left, taking into account that the vacations are already.
For 1, 2, and 3, all, my lord.
Keyboard also.
Yes. We appear for T-board, my lord.
And what about the 5 and 6? Housefed?
No, my lord, I don't.
Or Northeast Zonal Executive Officer, Northeast Zonal Office of what? Executive Officer of what? Keyboard.
My lord, mistake there.
And the next one also,
I may be allowed
Deputy, yeah.
I may be allowed to file terminate cost title, my lord.
Then
Sorry.
the counsel appearing on behalf of the petitioner seeks for an accommodation to file an amended cost title, taking into account that there are some clerical mistakes. Leave is granted to file the amended cost title. Liberty is granted to file the amended cost title. Matter be listed for motion again on 8th of January.
27.
This matter
What is it?
non-payment of contractual bill of rupees 2,18,097.
Contractual. Notice making it returnable. You are?
I am appearing on behalf of Mr. S.P. Chaudhary for respondent number 2 and 3, lords.
One for government.
Notice making it returnable on contractual bills.
Yes.
Okay, wait for some time. 3rd of March 2025. Miss Yu Das appears on behalf of the respondent number 1. So and so appears on behalf of the respondent number 2 and 3. Gustav. Taking into account that all the respondents are duly represented, extra copies of the petition be served upon them during the course of the day. The case of the petitioner herein is that pursuant to such a work order being issued and the petitioner completed the said work. However, the petitioner is entitled to an amount of rupees 2,18,097, which have not been paid in spite of being duly represented. The respondent shall bring on record their stand by filing the affidavit on or before the next date.
28.
Yes, what is the fishery? What is fishery doing? And the notice.
But they impugned the NIT is at page 15, man.
Yes.
The worship will note, my lord, there are two dates, 30/11/2024 and 4/12/24. The original is the next page, my lord. By this, general public are informed the tender is invited on 9/12/2024. Only, my lord, 4 days in between. And therefore, my lord, not only the petitioner, but many other societies.
What is this?
But normally actually 15 days is, don't know whether it is
Set aside. Issue a fresh notice.
normally, but here
Normally, what is the urgency?
from our side, we ask
Mhm.
deputy commissioner to issue the notice. From our side,
He can't do like this.
deputy commissioner will say no.
And what is this giving so many dates? 30/11, 4/12, why? Whenever he feels whichever date he wants, he will take it. Is it what the Morigaon DC does?
Instruction. I'll
No instruction, we set aside this, unnecessary. Ask him to do, what is the rule,
My
Mr.
lord,
Chaudhary?
the requirement is, my lord, 1 month, my lord.
This is under the Assam fishery rules.
Yes, my lord.
Show me the rule. Like,
So
give it to
Rule
me.
3 says, my lord, the 1 month. Rule 3 says 1 month.
There are new book also. New books, whenever it comes to the court, we sometimes appropriate it.
This, my lord, I don't know whether the cover is only new.
Oh, the cover is new. That's it.
Page 7,
We
my
have
lord,
it.
we have stated that.
Is there conditions of, the deputy commissioner so and so as the case may be shall fix a date ordinarily not later than custodian for sale of. Is, okay, where? Provided the procedure prescribed for fixation of the date of sale of all Iman at least 1 month in advance by written notice in Form 101 of the Assam Land Law.
Yes, ma'am.
So it is as per the proviso to Section 3, Rule 3. It has to be 1 month,
At least,
not less than a month.
yes.
Here it is 5 days.
5 days and holidays in between, my lord.
So under such circumstances, we ask him to float a fresh tender by giving them 1 month time. Huh?
Your lordship, lordship.
No, why I'm saying it, if I stay there, it is going to harm you later because of the fact that you are stopped from doing it.
Better.
You have a right, go ahead, you hold it, but do it as per law.
Yes.
That's all.
Stay,
Because if I stay, it will remain stayed, somebody will be enjoying.
delaying the matter.
Huh? And Mr. M.K. Chaudhary, the Learned Senior Counsel, appearing, assisted by so-and-so, appearing on behalf of the petitioners. Petitioner, na?
On petition.
Appearing on behalf of the petitioner, Miss so-and-so.
For 2 months.
Why we approach so late?
Oh, my lord, this was 4th of December, my lord.
Understood. It was finished on 9/12.
Yes, they came to know subsequently only, but had they come to know, perhaps they could have, my lord, because the no wide publicity was given. It's not only petitioner, my lord, the other cooperative societies nearby, they have also represented, my lord, I have annexed that also. 9 other cooperative societies in the neighborhood, they have also, my lord, represented.
Allow me 5 minutes, then I can take the instruction from the department.
Please do. I think this is better because they have also filed an application for cancellation. There are others. It will take after some time. Just wait. Otherwise, you see, why I don't want is to stay it will be, will harm you. Okay. Yes, what are you doing on this side?
What I'm doing, my lord. Here the
Yeah.
petitioner's father was allotted to work in the Bazaar railways for blacktopping. Blacktopping the amount of 1,39 lakhs and odd rupees. Now that blacktopping work has been over. Then additional work has been given to 23 lakhs. And during that time, the father got some illness, my lord. So the son was running with a power attorney. In the meantime, father expired on 17/11. Thereafter, my lord,
Now tell me, how can this court enlarge a period of time?
no, I will not. Only the 80% of the additional work that is left. That we have representation to the respondent of 5C and 4. Only that additional work that allowed me to complete it.
How will this court do that? Can this court permit such things?
But because otherwise, my lord, what it will happen, my lord, that additional work of hardly 20% of the 23 lakhs is left. That they will issue then notice that they will issue this.
This court would be then, you want me to go to Maligaon? Then, how can this court direct the respond number 3, 4, and 5 to allow the petition number 1 to complete the remaining work?
This is an additional work, additional 23 lakhs.
Additional and no additional, that is their lookouts. I can't direct that. If they don't do it, you are entitled to compensation.
Lord, so that representation may be disposed of, my lord. They have representation was filed on 5. Lords will
Mr.
plan to pay the
Esbora,
25.
appearing on behalf of the petitioner, seeks for an accommodation, list this matter on 6/1/2025 for motion. Presentation, no.
Production list, item 1, promotion.
Yes, what is this with the health department? What have you done?
Prior to my lord issuance of the NIT in question, there was a calculation which was done. It was an internal calculation, which your lordship will find at page number 19, my lord. Page number 19, my lord.
Yes.
May I just read out? Page number 19. Sir, considering the all India inflation rate for the month of September 2024, 5.49%, based on the consumer price index published by the Central Statistical Office, Ministry of Statistics and Program Implementation, Government of India, the calculated future price of 138 excluding GST for 1 year is 145.57, which is rounded to 146. This is the figure, my lord. Thereafter, my lord, they issued the NIT, my lord. NIT, your lordship will find, it starts at page 21, my lord. Page number 21. The NIT is dated 27/11/2024. Detailed notice inviting tender, outsourcing of patient dietary service for Tezpur Medical College, Tezpur. Tenders are invited by the principal cum chief superintendent of Tezpur Medical College and Hospital, Tezpur.
Did you submit your bid?
My lord,
Did
I
you
submitted, my lord.
Then what happened?
My lord, the most relevant portion of this tender document, your lordship will find at page 23, my lord. Page 23, the award criteria. Your lordship will kindly note, my lord. Award criteria. This service is outsourced for providing good, healthy, and nutritious food to the patient, essential for fast recovery. Hence, there can be no compromise in quality of service. Being L1 does not confer the right for award of contract. To avoid poor deficient service in abnormally low rates will not be considered. Therefore, a reasonable rate with quality service is mandatory. And in the event of abnormally low bids, authorities' preconceived notion will be final. This is what they say, my lord, that the preconceived notion, which I have already placed before your lordship, will be final. Thereafter, my lord, the technical bids were opened on 17/12/2024.
Next line.
Well,
However, the price quoted by the bidder shall not in any case exceed 160.
160. It cannot go above 160.
Then
Therefore, thereafter, my lord, the technical bids were open, which your lordship will find the minutes at page 32, my lord. Page 32, and the relevant portion is at page 33. Two parties were, my lord, found to be technically qualified. Serial number 1, my lord, Indira Enterprise Tezpur, that is me. And the second entity is, my lord, Jana Enterprise Kolkata. These are the two parties which are found to be, my lord, eligible. Thereafter, my lord, on 18/12/2024, the financial bids were open, which your lordship will find at page 34, my lord.
okay.
My lord, page 34, your lordship will see the comparative statement, my lord. Jono Enterprise Kolkata is rupees 111, which is much below the, my lord, the preconceived notion of the authorities. And my lord, if I may just place the schedule for providing the, my lord, the items, your lordship will find that schedule at page 28.
Yours is also not 146.
My lord, mine is 144, my lord.
2 rupees less.
Just 2 rupees less, my lord.
Now,
Now, my lord,
so now you are saying that he should not be given. Jana
because, my lord,
First of all, so far as the document at page 19 is concerned, this is an internal document, my lord. Thus, a particular figure has been drawn by particular statistician, and it's not part of the tender. So he cannot rely upon this and say that it should be given to him because some report was there that minimum should be 146, considering the
Then
present statistics. And being a tender, the tendering committee who will decide, and if the particular party, L1 bidder, if he allotted the work, if fails to supply it, in proper terms of the contract, he will face the It's not that
no. That is not the question. Here, kindly see the award criteria, which is a very relevant thing. Otherwise, I would not have. Otherwise, I would not. Here, the question comes about poor deficient here. At 111 rupees, you are paying, and because of that, if the patients are going to have a problem, that is another issue. Have you analyzed what is the difference out there? Obviously, it is for you to do. I'm not nothing to say. But the fact that we need to have an answer to this aspect. Why? Because your rate cannot exceed 166. One has quoted 33 rupees less. Now, have you compromised or not on that aspect? Because this, taking into account the award criteria, is a very relevant aspect. So we do one thing, we'll issue notice, stay till the next day.
You will give a short date.
I always give short dates. If I'm again taking a bench for, I will finish it off.
Yes, on in the second week of January in that case. The fact is, the present is the petitioner will supply. So internally he knows this thing.
so this was, my lord, uploaded in the official website, my lord.
And at what price is the petitioner supplying now?
130.
130.
If you give him now, ask him to supply, you don't give him more than that.
So that's it. That's a separate agreement.
To notice making it returnable on. Will it be possible on 8? 8.
On 8.
8, my lord, some difficulty, my lord. Can you turn 6 or 7? Any day?
I can even fix it during the vacation, but are you going to be able to serve it on number 5?
Take steps.
Should notice making it returnable on 9/1/2025. Mr. B. Gogo appears on behalf of the respondent number 1, 2, 3, and 4. And accepts notice. Extra copies of the repetition be served upon him during the course of the day. As regards the respondent number 5, the petitioner is directed to effect service by way of dusty routed through the registry of this court and file an affidavit of service on or before the next date. The petitioner herein is aggrieved by the decision of the respondent authorities, more particularly the tender evaluation committee, whereby they have made the respondent number 5 as a L1 bidder without taking into consideration the award criteria as mentioned in the detailed notice inviting tender dated 27/11/2024. Full stop. It is the learned counsel appearing on behalf of the petitioner has drawn the attention of this court that internally it was that to his information internally an amount of rupees 146 was found to be the appropriate price for the purpose of future for the purpose of supply of food, supply of
Dietary services, my lord.
diet
Patient.
diet for indoor patients. To stop. He submitted that a perusal of clause 7, more particular 7, and more particularly, perusal of the notice inviting tender dated 27/11/2024, more particularly the section wherein it has been mentioned as the award criteria. It has been categorically also opined that being the L1 bidder does not confer a right for award of the contract. Full stop. In addition to that, there is also an important aspect which requires to be looked into as to whether the rate at which it is supplied would be a reasonable rate taking into account quality service. Full stop. The learned counsel submits that the respondent number 5 have quoted an abnormally low rate that is at rupees 111, whereas the petitioner have quoted 144. Maybe the petitioner is the L2, but the tender cannot be granted to the respondent number 5, taking into account that it would not be conducive. It would be contrary to the award criteria mentioned in the detailed notice inviting tender. So this court, upon perusal of the award criteria as mentioned in the detailed notice inviting tender, the prima facie opinion that is of the prima facie opinion, and is of the opinion that the stand of the respondent authorities be looked into as to whether the said award criteria as mentioned in the detailed notice inviting tender has been duly taken note of. Full stop. This would require filing of an affidavit by the respondent authorities, more particularly the respondent numbers 1 to 4. Under such circumstances, this court fixes this matter on 9th of January 2024 on which date an attempt shall be made to dispose of the petition. Full stop. The respondents are directed to bring on record their stand by 7th of January 2024. In order to protect the interest of the parties, this court directs that till 9th of January 2025, the respondent authorities shall not further proceed with any settlement pursuant to the notice inviting tender dated 27/11/2024.
Clause number 1 of the award criteria. That particular clause is clause 1 of the award criteria, because there are various sections. 1 and 2 award criteria, 3 instruction to bidders. So separate clause 1 of the award criteria.
Yes.
Clause 1 of the
Award criteria, clause 1. Huh?
1 of the award criteria.
Obliged. Deeply obliged. Obliged.
Oh, it should be cancelled, Lordship. The tender should be said, Lordship, be said effect.
I got mute, sir.
Do not encourage these things, Lord. I talk with that.
Mr. M.K. Chaudhary, the counsel appearing on behalf of the petitioner. Mr. Sharma appears on behalf of the respondent numbers 1 and Mr. Miss Yuza, the additional senior government advocate, appears for the respondent number 2. The petitioner, which is a society registered under the Assam Cooperative Societies Act 2007. 2007. Petitioner is registered under what?
The Cooperative Societies Act.
Which one? 48?
40.
48. Have assailed the notice inviting tender dated 30/11/2024 oblique 4/12/2024 on the ground that the said notice inviting tender is in violation to the proviso to section rule 3 of the Assam Fishery Rules 1953. It is noticed that the proviso to the Assam Fishery Rules, a proviso to section rule 3 of the Assam Fishery Rules categorically stipulates that the notice of sale of the registered fisheries shall be at least a month in advance. It is noticed that the impugned notice dated 30/11/2024 oblique 4/12/2024 had fixed 9/12/2024 for auction of the fishery in question. The same is on the face of it contrary to the proviso to rules 3 of the fishery rules. Taking into account the above, this court therefore sets aside the said notice dated 30/11/2024 oblique 4/12/2024 bearing number MRF.4 oblique 2005 oblique PT oblique 41 issued by the respondent number 2. The respondent number 2 shall put to sale the said registered fishery by duly following the provisions of law. Petition stands allowed.
It should be auction, not auction. But the notice
You
says
say
sale.
auction, the fishery rule says sale. Which should I put? Sale oblique auction. Yes, whose matter is this? The next one. G2 Datta and 70 others.
Here the tender is with regard to hiring of vehicles in ONGC. To draw of lots. They conducted lottery for hiring the vehicles. Now, we have challenged the validity of the draw of lot. Milord, the reason for challenge is that, Milord, once you have decided to judge the merit of the tenderers on the basis of a lottery, that is luck and chance, you have to be, Milord, utmost careful in considering in assessing the eligibility of the tenderers. Here what happened in the draw, because their system is online. Once an applicant submits application, Milord, he gets a serial number, application number. And a housey is rolled. A housey, Milord, 4-digit housey will be rolled and a number will be procured, and that number will be the lucky candidate. Now here one ineligible candidate, because in the tender there is a criteria that only applicants are to be only from Jorhat and Golaghat. But in the draw of lot, not only ineligible candidate from Golaghat got an entry, that candidate got selected also.
Is it the tender notice? 10
Page 74,
2020.
my lord. Page 74.
And
Page 74, if you'll also kindly come, second paragraph. In connection with operation so and so wants to hire service brand new 52 light water vehicles, one applicant, one vehicle basis. That is the criteria. Now, if your lordships kindly come to para 2.1 at page 81. Page 81, para 2.1. This is the procedure for applying, my lord. First step shall be to have two options, sign up and login. New applicant shall have to first sign up using mobile number, email ID, Aadhaar, CAPTCHA. The authentication of mobile and email will be done through OTP. For other authentication, OTP-based authentication linked to applicant's Aadhaar registered mobile number shall be done. The applicant shall have to enter CAPTCHA while signing up. Once signing up, the process is complete successfully. Now, para 2.2, my lord, will kindly have of page 82. It says the second paragraph, mask, Aadhaar number, applicant's number, address, gender, date of birth as per Aadhaar card shall be available. Mobile number and email ID sign up shall also be available. Meaning thereby, my lord, the moment I enter my Aadhaar details, my address got automatically included in the app. Now, page 83, my lord, will kindly take up clause 3.0.
then
It provides that applications from individuals having valid employment exchange registration pertaining to Jorhat and Golaghat shall only be accepted. That means an applicant has to be resident of Milord Golaghat and Jorhat. But in the draw of lot, Milord, one person, one
clause, that clause is where?
sorry, Milord,
Where is that clause?
3.0, page 83.
Then
Then, my lord, B, on submission of application through the application portal, a system generated 6-digit number, registration application number will be allocated to each applicant, which will be considered for the draw of lot to be held as per schedule. Now, they have held a draw of lot, wherein, if your lordships kindly come to page 198, it starts the results of the draw of lot.
190.
198. I am concerned with page 199. This is only one example, my lord.
Then?
See, serial number 2, Ritu Porno Bosumatari. She was a resident of Gwalpara.
Oh.
And if your lordships kindly see the number, how it was derived, 4813, it was derived by virtue of housey. That is, one housey was rolled for units, another for tens, another for hundreds, and next is thousands. Now,
Why
so
do
far
you
as
say that they have to be a Gwalpara person cannot?
no, look, there, this clause 4, 3.0, my lord, it provides, and that lady, my lord, that applicant, serial number 2, her employment exchange was also from Gwalpara. That also I have annexed. Not only that she is a resident of Gwalpara, her employment exchange, page 193. Now, my contention is that the moment you allow entry of one eligible person in a process of luck and chance, judging the merit of the tenderer by virtue of luck and chance, the entire proceeding vitiated. Why I am saying so, my lord? You give an application number. Had she been rejected at the threshold, that application number could have been one of the petitioners. That is my submission, my lord. That there is a possibility. So you have to be utmost careful when you select the merit of tenderer by virtue of lottery. So that, my lord,
Now, how many people have come here?
my lord, the petitioners, 12
Total,
petitioners,
we require 52 vehicles.
52 vehicles and
Total applicants can be 70.
no, my lord, applicants
Can be many.
5,000 someone,
Maybe, but they will make the law, draw up lots out of 70.
yes, no, what they'll do, they'll shortlist 52.
No,
18 they will keep for
They
waiting.
will shortlist 70,
Sort
of which 52 would be given and 53 to
Wait list.
70 would be the wait list.
wait list.
Then what is wrong? One person, if you are or identifying one person is wrong, okay, they will consider if they don't find him out there, then the 53rd person will come in.
Milord, there also I have a submission, Milord. There
You
also
did
I have
not
a
come
submission.
within 70.
No, my submission is that, Milord. How you, Milord, suppose, Milord, I'll just explain. Milord, the housey was rolled 70 times to select 70 persons. Assuming this select number 2 lady who got selected, assuming they could have detected, they would have detected.
How many persons are wrong as per you?
Sorry, Milord.
How many persons?
Three, because they have allotted, they have issued NOA for 49 out of 52. Now, what I'm trying to, Milord, place before your lordships is that had she been detected at the time of rolling of housey, then, Milord, her number would have cancelled then and there, and the housey would have rolled again. Fresh housey. So out of 70, it could have been, if I go by 3 applicants.
No, Mr. Nag, that case, very.
I'm just, Milord, I just try to, Milord, persuade your lordship. I'm just trying to. So housey would
You
have been.
you must have already used your luck in some other way, somewhere.
No, Milord.
That is why you didn't have the luck on the housey day.
Milord, the problem is that if you are judging the merit of a person by virtue of a housey and lottery.
Understood. Therefore, why they are making it 70?
Milord, waiting list also I have submission, Milord. Say, for example, you have shortlisted 52. Where is how can you predetermine the luck of the waiting list person that someone will cancel and he'll get at that point of time?
Did you participate?
Yes.
Then why you are challenging are you challenging the term?
No, I am challenging the result of the draw of law.
Why?
That
without challenging the methodology which is being mentioned in the tender document, why you are challenging it?
Milord, I am not aggrieved by the methodology provided in the tender document. I am in the process they have undertaken. This was not provided in the NIT. That if how many times the housey has to be rolled. My submission is that, Milord, inclusion of a single ineligible person in a game of luck and chance will vitiate the entire proceeding. You should have done a fresh housey then and there, because you cannot prepare a waiting list at that point of time, forcing a thing that no, if someone get cancelled.
Your submission is this.
Yes.
Taking into account that there were certain illegible persons inside within the ambit of the draw of laws, you have vitiated the entire process.
Yes.
Because of the fact that if these people were not there, the luck may have come
true.
But that would be amounting to challenging the tender condition and having participated open-eyed. I think this is a fit case for issuance of a rule without a stay.
Some protection, your lordship, because
without a stay, issuance of a rule. And by 4 years,
I may not have a very good case to argue before your lordship, but the thing is that
this
one
will
point
be a
is there.
case of a constitutional court importance.
Look, one point is there that you have to be utmost careful in such type of tender wherein you are judging the merit, because no competitive price bidding serial number 1 to 3 merit is not there.
Mr. Counsel,
some protection,
no
Milord, they will supply the vehicle, Milord.
So
I'll
what?
be out.
They supply the vehicle, let them Mr. Chaudhary, you are paying
They'll
for.
supply the vehicle, I'll be out.
Yes, why? What have you done?
interesting thing is this very tender condition of draw of lots was put to challenge. The learned single judge has upheld, division bench has upheld, and SLP against that has been dismissed today.
That's on different ground, Miller.
But
That was tender was
The
challenged.
whole idea was, what was happening is, these petitioners and some had managed to monopolize the whole business.
No.
And they have been, it is their
No,
pleaded case.
that
my lord.
was- that-
Last 20 years, they are operating.
That was the
And
case in
To
Shivsagar.
break
not
that
here.
monopoly, we came up with a solution because there were used to be thousands of applications. In this, we got about 5,000 applications and we wanted only 52 vehicles. So we said that to keep it transparent and fair so that everyone gets a equal opportunity, we decided to adopt the policy of draw of lots. That policy was put to challenge, that has been dismissed. After that, another tender that has been dismissed. Now again, in an indirect way, again this petition comes. This is an absolute abuse. Once we file the affidavit, everything will be clear.
How many petitioners are here? Seven.
Eight petitioners, my lord.
And they haven't made these successful ones a party.
My lord.
Hardly 5 or 6 have been made a party.
In a representative capacity, my lord, I have made a party, my lord.
How?
Five persons I have made a party since.
52 are selected.
That is not possible.
Definitely
That is
I-
not possible. Do you know why? Where you cannot ascertain the amount. As per there is one judgment of the Supreme Court where you may do so in a representative capacity. But in a case out here, there are only 52.
Why I'm saying so, my lord? Why I'm saying so? Because I have challenged the validity of the draw of lots. Whether 52 comes or 5 comes.
The moment
would
you are
depend.
challenging the validity of the laws, every 50% will have a right. Can we tomorrow cancel on that basis?
I'll implead, my lord. There is no problem in that, my lord. I'll implead them. Lord,
Okay.
will kindly permit me to implead them. Only thing is that Lord will kindly give some protection. Some protection.
Only protection is that I am not dismissing your petition. That is the only thing. And today being a last day. Although I have time, and there are very less matters I could see out there.
It's true, my lord. Sometimes we don't come up with very meritorious cases, but
Not here,
I
not
thought
here,
that
no
my lord,
case.
some point I have to place before you.
Okay, issue notice making it returnable on 5th of February 2025. Mr. S.S. Roy accepts notice on behalf of the respondent number 1. Mr. B. Chaudhary accepts notice on behalf of the respondent number 2, 3, and 4. Good stuff. Taking into account that respondent numbers 1 to 4 are duly represented, extra copies of the petition be served upon them during the course of the day. As regards the respondent numbers 5 to 9, 10, the petitioner is directed to take steps by way of registered as well as usual. Good stuff. Mr. I. Chaudhary, the learned senior counsel, appearing on behalf of the respondent number 2, 3, and 4, has submitted that the instant petition is not maintainable, taking into account that all the person who have been selected pursuant to the notice inviting tender have not been impleaded. He further submits the question of impleading only a few does not arise in the facts of the instant case, taking into account that the total persons who have been already selected on the basis of the draw of lots have been clearly identified. The case of the petitioner herein, as would be seen from the materials on record as well as the submission made by Mr. H. A. Das, the learned counsel appearing on behalf of the petitioner, is that some of the three, as per you, three. The three amongst the various applicants who have been chosen to be who have been chosen in the draw of lots are not eligible in terms with the notice inviting tender. He therefore submits that the entire draw of lots, the entire selection so carried out by the draw of lots have been vitiated. This court is of the opinion that taking into account the above submission, is of the opinion that without taking the stand of the respondent authorities, it would not be proper on the part of this court to pass an interim order at this stage. This court shall consider passing of interim orders after service upon the stand being brought on record by the official respondents. Shall consider. This court further keeps the maintainability of the writ petition open. The respondents, official respondents are directed to bring on record their stand by filing their affidavits on or before the next.
Can it be subject, any change subject to the outcome of the writ petition? If any change is there,
Mr. Counsel, I'm saying that your interim order will consider with their, after their report.
fine, fine.
What else you?
I'm sorry.
I gave you more than that.
Yes, yes, much of it.
For admission item 13.
Here, my lord, I have received the instruction, my lord, no 3D notification was issued, my lord.
If no 3G is done, then what remains?
My lord, the petitioner has received the entire amount for the
But
10
without
lectures, my lord.
3D, there is no acquisition.
10 lectures, my lord, and she is in possession of the remaining 4 lectures, my lord. Still, she is still in possession of the remaining 4 lectures. My lord.
Understood, but as of now, you have not acquired. You have not acquired. The acquisition will happen when you have a 3D.
But money has already
Isn't
been.
it? If I am a bit correct, at the end of the year, one thing I could learn that without a 3D notification, there is no acquisition.
Correct. Yes.
That is correct,
In
my
our
lord.
affidavit, my lord,
Hello,
we
what
have
they say, my lord,
Yes.
what they say in the affidavit, just one paragraph, I'll read it out, my lord. In respect of dark number such and such of
I have
Khatwal,
looked into those affidavit, Mr. Mohanto. But the only thing is without a 3D notification, nothing remains.
That no point is question also involved because TG comes after T and TT.
3G will come later on.
Later, declaration will come later. After declaration will come TG. Now, what manner it was done without notification. without
Anyways, you
declaration.
have paid him whatever amount you have paid is subject to some indemnity being submitted by him. That is one aspect of the matter. But without, as of now, there is no acquisition.
As of now is.
Then what
not as
remains?
per law.
Ms. Yuda, the learned additional senior government advocate submits on instruction that there has been no 3D notification.
Against
No
the-
notification under section 3D of the National Highways Act of 1956 in respect to the acquisition proceedings. Respect to the acquisition proceedings. These are only submitted that there is a determination being made under section 3G. It is the opinion of this, it is the prima facie opinion of this court that without a notification under section 3D, there cannot be any acquisition. And that the land does not vest upon the state, central government, upon the central government. Ms. Yudas, the learned additional senior government advocate submits that the competent authority along with the central government shall take due steps in that regard. Do some steps. You can't do anything else.
There's an IA also, my lord.
For
They are
what?
not, I'm so sorry. If there's no 3D notification, my lord, we cannot lawfully take possession of my land, my lord.
It is
Now-
further observed that without a 3D notification, there cannot be a disturbance, the possession cannot be taken as per the National Highways Act 1956. And as such, the respondents authorities are directed not to disturb the possession of the petitioner till a 3D notification under section 3D is issued.
They've already destroyed my gate and everything by taking excavator.
Gate was in the government land. For that, Jirat has already been received. My lord, the gate and all, my lord, boundary wall was in the government land, my lord. And for that, Jirat has been received by her.
Jirat has not, that's,
Whatever may be, without a 3D, how can you do?
My lord,
Nothing
when
remains.
construction of this
Don't
wall
disturb anything, don't do anything without a 3D. Establish this matter when? When you will come up with a 3D? You are the main person.
Because the treaty will be published by Kala.
3D is not published. It's by the central government.
Central government will do, but this will be prepared by the, this always will be prepared.
Then
by
why you are not taking any steps? Okay, list this matter on 5th of, on 7th of February 2025 for an update.
clear, like,
14.
Well, I have received the instructions from the ADC, Milord. Well, the Lordship may kindly see the serial number 3, Milord. Serial number 3 in the instruction. Well, they could not release the payment because of some mismatch in the revalidation, Milord, the Milord.
Have you taken over his land?
Well, that has been taken. That has
Taken.
been taken, yeah. That has been taken.
Payment is to be made by the central government as per 3H1.
Yes, Lord.
Has the payment being made?
Well, the process is at the,
Who appears for the central
the
government?
central government.
How is it possible that you take over the land without making payment? 3H1. What procedure? You have not made the payment. Kindly see 3H1 of the National Highways Act.
Well,
Nothing doing.
well, the process is, well, that this.
Return. This is absolutely in violation.
Well, the MOT will update the head of account in the portal, Milord.
We are
And-
not
and-
concerned.
account
We are
number-
not
account number,
concerned what the
everything is
mod
there.
does, what whoever does. First of all, we are to concern with the Constitution. The Constitution categorically mandates you cannot take somebody else's land without payment of due compensation. Where is the compensation? Is he going? Do you want the petitioners everywhere to keep on begging? The person who are the owners of the land to become beggars? Tell me. Do both of you have the National Highways Act with you? Fantastic. Hey, National Highways Act continue. I got video. Hello. Yes, read 3H1. Three H1.
The amount determined under section 3Z shall be deposited by the central government in such manner as may be laid down by rules made in this behalf by that government with the competent authority before taking possession of the land.
Then, how did you take the possession? That's the law. 3H2.
Well, as regard 3H2, Milord, as regard 3H2, Milord, now the process is that directly the amount.
We are not concerned with your whatever you may have process. But why did you disturb the possession of the petitioner without making payment?
Lordship, road has already been constructed.
No, road has to be constructed. You take a toll. You allow him to collect tolls. You can't help it, do it in this manner.
That's. Well, in the.
Who are the officials concerned? The central government, yours, PWD, Chief Engineer PWD.
The PWD, my lord,
Chief Engineer PWD shall bear the concerned official of the Chief Engineer PWD as well as the officials out here shall bear the interest personally. That would be the order.
my lord, the
No, nothing doing.
kindly,
Because that is the law. If you don't make that, we are not concerned. Tomorrow you are fighting amongst yourselves, whatever may be, we are not concerned. But the fact that he is entitled to, you have constructed a road upon her possession taken, you don't do anything. This is not how the law is. The
But
Supreme Court has been time and again saying this. And the interest has to be borne from you, from the officials. You get the name of that official and his savings bank account.
the revalidation.
And if he's working out there from his, all these retirement benefits will be given to him. If the interest is not there.
All of the revalidation has been done. Revalidation has been done. Amount is there, my lord. In the portal, my lord,
I'm not concerned.
kindly,
But who is going to pay the interest? The interest is going to accrue. Tell me, isn't the interest accrues because the law, the compensation has to be paid in terms of the Right to Fair Compensation Act, which will include the interest also? Then who's going to pay?
A lordship from last.
Tarsam Singh's judgment categorically says that you are to pay the interest also. Then
From last 1 year, he has been fighting the petition.
fighting along with the cost.
Yes.
You must have taken fees around 10 lakhs.
No,
Oh.
no, you're not. It's a minimal amount.
You have not
He's a
taken fees.
Farmer.
Huh?
He's a farmer who does farming.
He's a farmer, but he has to
And-
pay the
and
cost
has
of
been
the
taken.
litigation also. From the pockets of this chief engineer and your,
my lord,
the secretary.
but the
Mott.
amount calculated, let the amount be released. My lord. Lordship may take it up.
We have it on third.
Reopening.
We have it on third. We want that the amount be credited to his account. Nothing doing. This matter again on third, on which date the Mr. D. Nath appearing on behalf of the PWD roads. What is that? PWD and National Highway. National Highway,
Just a minute. Yes, and it.
PWD National Highway, as well as also the competent authority for land acquisition shall give an update as to whether the amount have been disbursed to the account, to disbursed to the petitioner. List the matter accordingly.
Item 16 to 18.
What are these?
Lordship, this matter relates to a decision-making process as far as the tender issued by the notice issued by the ONGC is concerned. Lordship, what had happened, tender was in, NIT was issued by.
Madam, we have it after vacation. These matters, any urgency?
There is a stay, it can be any day after the vacation.
Huh?
Any day after the vacation.
Is it stay?
There
I
is
have a stay, I have a stay.
The matter would require an elaborate hearing. You were asked to obtain some instruction.
Yes,
Lordship, we had filed an additional affidavit of that.
I have to respond to
Basically,
that.
what is the stand of the ONGC department with regard to the IM's opinion?
I have to file a.
Pursuant to the order dated 9/12/2020, the ONGC has filed an additional affidavit in WPC number
3345, Lordship.
3345/2024. However, the said affidavit in additional affidavit is not on record. Full stop. It is also submitted that there is a stay order operating, and as such, there's an urgency has been expressed by the learned counsels appearing on behalf of the respondents to list this matter on 28/1/2025, on which date an attempt shall be made to dispose of the petition liberty is given to both the parties to to either of the party to mention the matter for upgrading. Interim order passed earlier shall continue till then.
Earlier date possible, if any earlier date is convenient also.
What?
Any earlier date.
We can on 13th or 14th of January. Fantastic, you come over.
Interim order in item 18 also.
Yeah, that
16,
continue.
17, 18, all three items there are interim.
So those will continue.
This is one order. There will be only one order. We'll have only one order will do.
19.
Lordship, I am appearing for Karbi Anglong Autonomous Council. Lordship.
Mr. Ganguly, there is only interim order in one petition or all the petitions? It's okay. So then we say the interim order will continue till the next day. Yes, what is this?
I am praying for 3 weeks time to file my affidavit. Lordship.
Oh, yes. The learned counsel appearing on behalf of the case, he submits that 3 weeks time is required for filing the affidavit. So this matter, what is wrong with you? This matter has been going on for a long time. You are not filing affidavit.
The concerned joint
You make it absolute.
The joint secretary had a heart attack. Lordship. Therefore,
Heart attack,
yes, the joint secretary. Lordship.
3 weeks time for filing the affidavit in opposition. This matter again on 19th of February 2025. Interim order passed earlier shall continue till then.
Committee item 31.
Yes, affidavit filed. Have a copy of it.
Not served to me. Not served to me, but has informed.
Who has filed? GMC has filed affidavit. You have a copy of it? Oh. The instant writ petition has been filed challenging the inaction on the part of the GMC authorities in not demolishing, in taking steps pursuant to notice issued under section 337 of the GMC Act 1971. It is seen that during the proceedings, it is seen that pursuant to order passed by this court on 6/11/2024, 7/11/2024, 11/11/2024, and 18/11/2024, the GMC have taken appropriate steps in the matter. Full stop. It has also been mentioned that the respondent, that the 6th and the 7th floor of the building in question have also been demolished.
I know it is under process of being demolished.
It is in the process of being demolished. And to that regard, an affidavit has also been filed by the GMC authorities. GMC? Yes. GMC authorities bringing on record the photographs in that extent. Full stop. It is also taken note of that in respect to the violation of, in respect to the violation pertaining to the 5th floor of the building, there is an injunction which has been passed by the learned civil court. And as such, this court would not like to comment on that, as the list is presently pending before the civil court. So be that as it may, this court, taking into account the action which has been taken by the GMC authorities, does not find it, is of the opinion that nothing further remains in the instant writ petition to be decided, inasmuch as the GMC authorities have already taken steps pursuant to the 337 notice under section 337 of the GMC Act. This court, however, directs that the GMC authorities, the Commissioner GMC, to ensure that the demolition of the building particular in respect to the demolition of the 6th and 7th floor of the building in question is completed at the earliest. Full stop. But above the instant petition stands disposed. In fact, 2 days back, another judgment has come. Have you seen that? The Supreme Court has said that
32.
if the GMC or any authorities out there, they don't do anything for a long time, that does not give any right to the person to continue to have to continue to remain in an illegal constructed area. 2 days back, no?
I'll find it.
Huh?
Demolition is being carried out by the private respondent themselves. The lordship will kindly indicate in that.
The placement undertaking that we are going to
Doing it
do,
for
they are doing it,
only
but
that part.
one application has been filed that it will require some more time. They are paying for 6 weeks. The middle portion has already been demolished. Only that slab portion.
I'll put it.
Apply.
In 32.
Yes, what has
Not
happened?
every time they are taking time, they have not passed
Yes,
the
my
order.
lord. I, my lord, personally took up this matter with the honorable speaker, my lord. Because of some issues, my lord, the final order could not be, my lord, and he wanted to write a very
Bhuya kindly appreciate one thing.
quality order, my lord, and for
No,
that
Mr.
purpose,
Bhuya kindly appreciate one thing.
my lord,
We respect
my lord,
the office of the speaker.
definitely,
And as such, we have constrained ourselves of not passing any order.
my lord, absolutely, my lord.
By your conduct, don't compel us that we should issue a writ.
My lord, may I pray, my lord, one thing, my lord, is there, my lord, that
As
he
far as
intends to,
you
my
have
lord, he
seen the
was,
Supreme
he
Court
was in
judgment
between
which
unwell,
says
my lord.
that within 3 months,
My lord,
one should have done it.
my lord, there were
The
reasons
petition
for
has
that,
been
my lord.
filed was
He was,
filed
may
3
I
months
pray,
back.
one thing, my lord. My lord, I personally talked to him, my lord, and he apprised me and he assured me, my lord, it will be, he was unwell in between, my lord. And he wants to write a quality judgment on this, my lord.
Quality, don't quality means quality means.
My lord, with regard
No,
to my lord,
Mr.
and
Bhuya
he
kindly
wants to,
see.
he
No,
of
Mr.
his own, my lord.
No, Mr. Bhuya.
Yes, my.
25/11/2024,
Yes,
you
true, my
gave
lord.
an undertaking that the hearing has
Yes.
already been completed and the
Yes.
order is likely to be passed in 2 weeks.
My lord. No, my lord, 25/11, my lord. Thereafter, there was, my lord, a conference in Singapore that I have mentioned, my lord. Singapore, and they came back.
Therefore, we fix it after 1812.
Almost a month.
Absolutely, my lord. And may I pray, my lord, let it be on fourth on that particular next date, my lord. I will be producing the copy of the order, my lord. That order, my lord.
We fix it on 6th. Once you pass the order, if you don't, we will be compelled to pass
My
order.
lord.
Then later on, don't say.
No, my lord, definitely.
Because otherwise, and I don't want to reflect this aspect
Absolutely,
in
my
my
lord,
order.
absolutely.
Because you see, reflecting these
My
aspects in the
understanding
order.
to realize one thing, my lord.
Yes.
Under the 10th scheme of 10th schedule, it has been made a tribunal. So, my lord, everybody is bound by constitution.
Yes,
Merely
that's
because
true, that's
somebody is a speaker, my lord, he does not enjoy
Nobody is
his
above law, my
status.
lord. That,
No, that is
My
why,
lord.
Mr. Chaudhary, I fixed the matter day before
Yes,
yesterday
yes,
was there.
true,
I
my
fixed it today.
true, my lord.
Idea was that they will
Fact
come up with an
otherwise,
order.
if they don't do it, means we will be compelled.
Right.
And if you want, I can record these aspects which may have a repercussion on you.
Absolutely, my lord. So may I pray, my lord,
You
that is
don't
the
do
date
it, I
be
may-
fixed, my
I-
lord.
I'll
On
be
that day, I
compelled to
assure,
pass
my
on.
lord, on behalf of honorable speaker, that the copy of the order would be before this honorable court.
No,
I
no,
assure you.
why can't
He
you
wants
pass the
to-
order within a week from today? Why should you wait till 6th, my lord? In the nature of.
No, he need not. He has to pass an order.
Exactly.
I am fixing it on 6th.
6th, my lord.
On which
Definitely.
date he will
I'll
produce the order.
present the copy of the order, my lord.
I'm fixing it on 6th, he'll produce the order.
My lord.
And
Deeply
if you
obliged.
don't, we will be compelled.
My
to
lord.
pass.
Deeply obliged for commenting to that extent.
Mr. A.K. Bhuya, appearing on behalf of the respondent number 1 and 3, submits that on account of certain difficulties, the order could not be passed. However, it has been assured that the order would be passed on or before the next date. Or would be passed at the earliest.
At the-
Full stop. List this matter on 6/1/2025. It is observed that if no order is passed in the meantime, this court would be compelled to execute to appropriate directions.
Deeply obliged. Deeply obliged. Deeply.
Time being item 12.
Oh, your matter. Yes, what is happening?
Lordship, the remark, column from the remark column, it has been omitted from
Remove.
September. Lord, it's
Mark it as X and keep it
not
on record.
clear, Lordship. Because it was received through Lordship. At 53. From 53. Yes.
Remove. The heard Mr. Kane Chaudhary, the learned senior counsel, assisted by so and so, appearing on behalf of the petitioner. Mr. S.S. Roy appears on behalf of the respondent numbers 1 to 6.
All the response.
Pusta. The instant petition has been filed by the petitioner being aggrieved by the remark book in the workload return of contractors by the respondents as slow progress. Pusta. The learned senior counsel appearing on behalf of the petitioner submits that the remark so put is totally arbitrary, taking into account that it was not the fault on account of the fault of the petitioners that there has been a slow progress. The learned counsel has senior counsel drew the attention of this court to the tender conditions which stipulated that the structural steel has to be obtained from a particular source, and the petitioner thereupon have represented before the authorities concerned that these particular source as mentioned in the said tender condition did not provide him, had either no stock or were not interested in supplying such small quantity, and the petitioner therefore had requested the respondent authorities to pass appropriate directions for giving alternative source for the structural steel. The learned senior counsel submitted that in the instant case, it is in the instant case, as it is not the fault of the petitioner that there has been a slow progress, the actions needs to be interfered with. Mr. S.S. Roy, the learned counsel appearing on behalf of the respondent numbers 1 to 6, submits on instruction that although the petitioner's name was put as
slow progress.
Petitioners, although in the petitioner's workload return for the month of June 2024 have been
Quarter ending, June
the
20.
quarter ending June 2024, it was mentioned as slow progress. But however, subsequently taking into account the representation so submitted by the petitioner, the workload return of contractors of the petitioner for the quarter ending September 2024, it has the remarks of slow progress have been removed. In that regard, he has placed before this court an instruction had placed before this court the workload return of contractors for the quarter ending 2024. Also, the same is kept on record and marked with the letter X. Also, taking into account that for the workload return of contractors for quarter ending to September 2024, the slow progress the remark of slow progress is no longer there. Also, nothing further remains in the writ petition, in which the writ petition stands closed.
My lord, now they will allow us to buy from the dealer.
No, Lordship, that I have no instruction to that. Because for the slow
My lord,
progress,
now the same thing will happen if that actually, my lord, the Shillong authority has written. Or the higher
It
authority.
is further observed that the petitioner herein. Full stop. Before parting with the record, this court, however, finds it relevant to observe that the petitioner would be at liberty to approach the respondent authorities for approach the.
My lord, we have already approached and the intermediary authorities have already recommended. For a moment, if your lordship will kindly come to page
I've seen that.
50.
Yes, sir. Before parting with the record, this court further finds it relevant to observe that relevant to observe and direct the concerned respondent authorities to duly take care of the grievance, to duly consider the grievance of the petitioner pertaining to
My lord, on 24/11/24, page 54, my representation.
pertaining to the representations so submitted by the petitioner pertaining to non-availability of the structural steel in respect to the person, in respect to the firms mentioned in the tender notice and in the contract. And the recommendations so made by the along with the recommendations so made by the intermediary authority.
For orders, item 21.
Yes, what is this?
No confidence motion was noticed to the ADC lordship. On that lordship, ADC has written to the executive officer that this is not the right forum.
Regarding notice, regarding moving of no confidence motion, inviting reference to the Iman of the order. So nothing remains. In view of this, nothing remains.
In view of this may be closed. Actually, ADC convened the meeting, Your Lordship.
No, now the convening meeting has happened. You were only worried with the fact that they have taken any action for removing this. Okay. So now, and why is the executive officer there? You were the chairman.
I am the chairman.
And what remains now? Why is the executive officer there? That means the municipal authority has been dissolved.
No, chairman is continuing, Lordship.
How?
Lordship continuing, Lordship. 5 years term, Lordship.
Lordship, 5 years. This was given a notice to the ADC for convening a meeting for no confidence motion.
Understood. No confidence means presupposes that there is a chairman.
Yeah.
It further presupposes that there is a body. Isn't it? Why this letter is addressed to the executive officer? Executive officer means somebody has been appointed under 41, section 51. Means there is the AR has been dissolved. Otherwise, you don't have the executive officer. Can there be an executive officer?
There is an executive officer.
No, there cannot be an executive officer. Unless there is a case of dissolution, executive officer doesn't have anything.
There is a government appointed officer to assist the board, Lordship.
No.
Yes.
Can there be an executive
Yes.
officer?
There is an executive officer, Lordship.
To assist the board.
To assist the board, Lordship.
Under what provision? How? Municipal Act. Municipal Act.
53, Lordship.
Huh?
53, Lordship.
What does it say?
Appointment of executive officer. The state government shall appoint an executive officer for each and every municipal board and town committee and shall bear the expenditure in respect of pay and allowances of such executive officer in the municipalities having a population of 1 lakh and so. The executive officer shall function under the overall control of the board.
Okay, so the board. Okay. The heard Mr. M.K. Hussain, the learned counsel appearing on behalf of the petitioner, and Mr. S.S. Roy, the learned counsel appearing on behalf of the respondents.
1, 2, and 3.
2 and 3. Yes, sir. The present petition has been filed by the petitioner challenging the requisition, challenging the requisition dated 26/4/2023 and the notice dated 6/6/2023 convening the no confidence meeting on 9/6/2023. It is taken note of that this court, pursuant to the writ petition being filed, had stayed, had directed the respondent number 2 not to proceed with the proposed meeting to be held on 23/6/2023. Today, when the matter is listed, it is Mr. S.S. Roy, appearing on behalf of the respondent number 2, has placed before this court a communication issued by the respondent number 2 to the executive officer of the Doboka Municipal Board, whereby it has been categorically mentioned that the submission of the wherein it has been mentioned that the communication that the requisition so made to the respondent number 2 was contrary to the provisions of the Assam Municipal Act 1956, and as such have returned the same by observing that it was not the right forum to place the above motion by the requisitionist in absence of a specially convened board meeting. The said instruction is kept on record and marked with the letter X. Taking into account the above, nothing further remains in the instant writ petition, then the writ petition accordingly stands closed.
All right. Good.
Supplementary item 33 and 34.
My lord, despite there is a stay order operating, my lord, on some pretext or the other, some notices are being issued. Now, in respect of one of the shelter home, my lord, because the rent was not paid because they've stopped payment, so we had to shift that place, my lord, to another place.
What is this IA for?
IA, my lord, basically we are seeking some restraint order in respect of, my lord, notice at page 66 and 69.
Restrain the respondent, including the district authorities, from making any inquiries, investigation without appropriate leave of the court, especially when the case is pending.
My lord, my prayer is let the matter be listed immediately after vacation status quo as on today be maintained, my lord, in respect of the notice.
But why you are concerned?
My lord,
about the
actually what
status quo?
happened, these are being run from rented premises.
Huh?
These are being run from rented premises.
Okay.
Now, my lord, since no payments were made, so my lord, we had received notice from the landlord, we have to shift to another. So what they are doing, my lord, they are holding inquiry one after another. On one hand, you are not making the payment. On the other hand, you want that we should, comply with all the requirements. Now, the landlord has given us a notice on 2/11/24, my lord.
Which notice?
Yes, page 69 of the IA, my lord.
Chief Secretary of Neighborhood
Yes.
Lifeline.
Area rent and for vacating the rented house.
Really?
And we have intimated the authority by page 71, my lord, that we have shifted.
Shifted?
Yes, to another premises. Naturally, we have to shift, my lord. Now they say we went for an inquiry, we couldn't find you. Naturally, my lord, we are not there because of the notice we shifted at page 71. We
No, this is
intimated,
a notice by a private individual.
my lord. No, this
By-
was by my landlord, my lord.
Landlord is a private individual.
Yes.
To you, you are
Because
neighbor.
I am the NGO running that, my lord, shelter home.
Okay, so you are being asked to pay area rent and
Yes.
vacate,
Vacate.
and you vacated.
I vacated, which I informed at page 71 on 27/11/24. In spite of that, now they have again issued notice, my lord.
Request
30/11.
for temporary shifting of Sadhan. He has been operating for immediate approval to shift. So you wanted to shift,
Yes, we shifted, my lord, in fact.
and where is the shifting order?
No, there's no shifting order, my lord, because we have shifted.
No.
We have
We assure-
intimated the authority.
Now, we assure you that this relocation is temporary, once also you have shifted. Okay, now what has happened?
Now, my lord, this notice at page 66 is there.
66.
Yes,
By whom?
by the authority, my lord.
Okay, fine.
Regarding inquiry of Shakti Sadan and re-verification of physical progress report with statement of expenditure. Every time something or other is being happening. On the contrary, my lord, our payments are due.
So
My lord,
this
all
is
that I
being
pray
done
for,
by
let them
them.
have the instruction also, my lord. In the meantime, they will not take any coercive measure, my lord. And let the matter be fixed on 6th. Today, my lord, there is hardly any time also left.
You and me are the last, I think. Yes, social welfare.
But it's to be conducted as per the, my lord, page 66, my lord.
You do one thing, you
My-
go ahead with the
Uh-huh.
inquiry,
my-
but don't take any coercive.
Coercive measure, that's all.
Is to, yeah,
The instant application has been filed by the petitioner in WPC number 1638 of 2024, challenging, seeking certain interim directions. Mr. Kane Chaudhary, the senior counsel, submitted, appearing on behalf of the petitioner, submitted that that the respondent authorities are respondent social welfare department, the district social welfare department
Okay.
officer is causing unnecessary harassment to the petitioner in the name of the inquiry. And the petitioner and the applicant, petitioners fear that course of action would be taken without proper inquiry. Ms. Yudas, the legal counsel appearing, additional senior government advocate appearing on behalf of the respondent, submits that she will take instructions in the matter. List this matter again on 8/1/2025. Taking into account the above, this court directs the applicant oblique the petitioner to cooperate in the investigation inquiry. However, the respondents, more particularly the district welfare officer, Dhubri, na? Dhubri, is further directed not to take any course of action against the petition.
But in the main writ petition, interim order will be extended. my lord.
Interim order is there.
Yes. 27/3. This is a speaking order, my lord, after instruction.
List this matter again on 8/1/2025. Interim order passed away shall continue.
Deeply. So this is the last case of 2024, my lord. As far as I am concerned.
No, there is there.
Oh, Mr. Das is there.
M35 and 36.
We file an application for procurement, but I have seen the number of cases have been fixed by lordship on the first week.
No, it is not possible on the first week,
Why it's
not
not
possible,
possible?
second week also
No,
not
my lord,
possible.
It's not possible. Only one prayer can I make. It is not possible. I have seen number of cases. Can be on 21st.
Hmm?
21st.
21st.
21st of
There's a
January.
lot of matters if you see. 21st, we have 22 items.
So whichever date is convenient.
See, that is why-
28th, your lordship has fixed this matter. 23rd. And only one request, my lord, can it be on top of the list?
Why top of the list?
But there is
Top
some.
of this matter.
Whichever
has
it
to
goes, my
fulfill.
lord, we don't mind, this way, that way.
No, no, no. There might be other top of the list.
Or liberty should be given to mention us, my lord.
Leave this matters again. Now, the instant application has been filed seeking preponement of the where is that order, last order first? Main order ko the?
7-11, I think, last order.
Hey, order bol nahi dekhon.
Yes. This one, I mean, it's good, isn't it? We have annexed that. Page 26, we have
There's
annexed
another one, 350, 3355.
35355. We have
it
annexed that order. Which your lordship will find.
Why is it necessary? We have already 20. Only. It is already there. It hardly makes a sense. From 23rd to 28th, there is only this day. And anyways, thing is, I am not there. So anyways, let it be placed before that else.
No, my, let it be on 28. Let it be your lordship 28.
28.
28, let it be on top of
28
the
only 3 items. I
But
think
let it be on top of the list.
it's already, it will come up.
Top of the list. my lord.
The instant application has been filed. There are many applications. How many applications?
No, we have filed two only. Two read petition.
The instant application, the instant application has been filed, 4,000 to for preponing the date in WPC number 3366, 3355/2024, which is otherwise fixed on 28/1/2025. This court have duly taken note of that as on date, this court have duly taken note of that the calendar does not permit that a matter can be preponed. The calendar can, so under such circumstances, this court is not inclined to prepone the hearing in respect to the petition. Be that as it may, this court grants liberty to the petitioner, to the parties to mention the matter for upgrading. Mr. So-and-so appears for the respondent.
I is disposed.
I sense disposed. I gonna do AK order over the 4,000.
I is disposed of. Yes. He'll come for admission here.
Come up.
Yes.